Lauren now. And then can I have your email address so I can send you the link?
Yeah, it's hurlmark1.
Get stuck on a Zayden bridge. Nope.
Good morning, everyone. I call our meeting to order, and I welcome Justice Dalila Wendlandt, Associate Justice of Massachusetts Appeals Court, and I'd like to welcome her family, Jeff, Cora, and Elise, for being here this morning. And I know that you have friends that are also watching from home or from office, and you have others that wish to participate in the hearing process, and we'll hear from them in just a few minutes. We would like to welcome two chiefs here this morning, Chief Justice John Casey of the Probate and Family Court and Chief Justice Mark Green of the Appeals Court. And I know your colleagues on the Appeals Court, of course, being 24, would all like to be here in person for you, but because of the COVID requirements, they will be cheering you on from afar. But you can see in this room, given the vast nature of the ceiling height and the distance through the walls here, we have plenty of room for us to situate and have our hearing today. We also have Justice Ariana Buono, who is also here with us. Good morning and welcome today. I'd now like to turn it over to Governor Baker to introduce our nominee.
Well, thank you very much, Lieutenant Governor, and I just want to say once again how much we appreciate the thoroughness and the respect that you show to all of the nominees that we bring before you. And I especially want to say hello to Councillor Hurley and Councillor Ferrara from their faraway places. It's nice to see both of you, and of course, Councillor Ionella, Councillor Jubenville, and Councillor Kennedy. Thank you for being here as well. We went through a very similar process with Justice Wendlandt about 4 years ago when we nominated her to serve on the appeals court. And I would just simply say that we had very high hopes and expectations for her when she was nominated and ultimately approved by you. And she certainly has exceeded those as a member of the appeals court. And I won't get into much of the detail because I'm sure you all know it and have questions and issues in particular concern of yours that you'd like to raise. I'll simply say this. Justice Wendlandt is one of those people who brings a tremendous amount of intellectual horsepower, kindness and grace, and a real appreciation for the complexities of the law and the simple notion of justice to the work that she does. And I think she would be a terrific member of the Supreme Judicial Court, in part because she's been a terrific member of the appeals court and because her colleagues and those who have practiced in front of her literally speak so highly of her that at times I find it to be a bit overwhelming. And I certainly look forward to the results of your meeting with her today, and I certainly hope that you will seriously consider her qualifications, her experience, and her potential to be a truly special member of the Massachusetts Supreme Judicial Court. And with that, I will turn the floor back over to all of you. And again, I appreciate your willingness to bend to the facts of COVID and to be willing to operate under what are certainly different circumstances than you would normally be handling a hearing like this. Thank you.
Thank you, Governor, for your time this morning and for introducing our nominee. We are very proud to have you here today for this hearing. I am going through our COVID rules, which the governor is quite familiar with, so he will depart at this time. I would just like to acknowledge, a room set up like this just doesn't happen. It takes a lot of coordination and effort, and I do want to thank Dean Serper and Grace Robinson, and then all of those behind the screens of Joe Ferreira and Mary Hurley for their attentiveness today so that we can hear each other, we can feel safe and comfortable in this room, and those who are not in the room can participate fully in this hearing. So just thank you for the extra effort to make this possible today. So there are a few more rules, obviously spacing, distancing, hygiene, no food or drink into the hearing room. Everyone must wear a face cover unless you're speaking, and obviously those at home, you comply with your own rules. And we will avoid gatherings as we come and go out of this room. And relative to the hearing, Justice Wendlandt has 4 witnesses. 2 will be here in person testifying, and 2 will be participating through the WebEx that has been set up. And this is being live streamed via YouTube, so many friends and family members can be able to observe the hearing. And I want to thank all of the Governor's Council members for their hard work, both at these hearings and outside of this hearing time, with regard to vetting the nominees and the candidates that the Governor and I present. I'd now like to introduce the members of our Governor's Council. Joining us remotely is Councilor Joseph Ferreira from District 1. We have District 2 Councilor Robert Jubenville. We have District 3 Councilor Marilyn Petito Devaney, and District 4 Councilor Christopher Iannella, District 5 Councilor Eileen Duff, District 6 Councilor Terry Kennedy, and District 8 Councilor joining us remotely is Mary Hurley. We will be chairing and organizing this hearing similar to what we've seen in the past. In a few minutes, I will read the Governor's letter of nomination, and then I will ask Justice Wendlandt to introduce her family, who is here this morning. I will then ask Justice Wendlandt and any witnesses, both in person and participating through WebEx, to take an oath, and you'll stand to do that. And then we will hear from witnesses. First, those in support of our nominee, and then those who are in opposition. Then Justice Wendlandt will present her opening statement, and the questions will begin, starting with Counselor Marilyn Devaney. We will take a break at noon as the Governor's Council has an assembly and some business that they need to conduct at that time. We'll break for about an hour and then come back to resume the hearing. So, dated November 3rd, 2020, a letter to the Governor's Council members. I am pleased to nominate Dalila A. Wendlandt to the position of Associate Justice of the Supreme Judicial Court. I submit this nomination for the advice and consent of the Executive Council pursuant to Part 2, Chapter 2 of the Constitution of the Commonwealth of Massachusetts. I'm enclosing the nominee's resume for your review. Sincerely, Charles D. Baker. Justice Wendlandt, could you please introduce your family to us today?
I'd be happy to. Thank you, Lieutenant Governor. Thank you, Governor. I have with me today, I have my husband, Jeff, and my two daughters, Cora and Elise. And my son, John, is watching from College Park. Go Terrapins. So.
Okay. All right. I would please ask anyone wishing to testify, including Justice Wendlandt, and those who are presenting via WebEx, to please stand and raise your right hand. Okay. Do you swear to tell the truth, the whole truth, and nothing but the truth? So help you God.
I do.
Okay, thank you. Okay. We would now like to hear from our first witness, and that is Justice Buono. Justice Buono, you can present your testimony.
Thank you. Thank you very much, Lieutenant Governor. Can everybody hear me?
Yes, we can.
Okay, great, good. Good morning to you, Lieutenant Governor, and good morning to everybody else who is in the great hall this morning. Good morning to members of the Governor's Executive Council, to my friend and colleague, Justice Wendlandt and her family, and to all of you who are watching this on the YouTube live stream this morning. In particular, I want to say good morning to all of my colleagues who I know are participating via that platform. It is a pleasure and an honor to be with you today to speak in support of Justice Dalila Wendlandt's nomination to the Supreme Judicial Court. I applaud the Governor and the Lieutenant Governor for nominating such a worthy candidate. And I want to pause for a moment and thank you, all of the Governor's counselors, for confirming Justice Wendlandt to the Appeals Court a few years ago, because you gave us a terrific colleague. And if I'm not mistaken, all of you, with the exception of Counselor Duff, who was not on the council at that time, voted in her favor. Well, you were right to do so because Justice Wendlandt is quite simply an outstanding appeals court judge. I don't say that lightly. I've had the privilege of serving on the appeals court for nearly 15 years. During that time, this body has confirmed so many exceptional judges to the appeals court. But I can say unequivocally that Justice Wendlandt is one of the best of the best. She has a keen intellect, a warm heart, an incredible work ethic, and a sincere commitment to the court as an institution. Her knowledge of complicated civil litigation is vast. She is collegial and humble. She understands technology. She has an uncanny ability to listen, to learn, and then contribute to a discussion in a persuasive, strong, but importantly, a cordial and respectful manner. In deciding cases, she is faithful to the record and precedent and is a clear, thoughtful, analytical writer. She also has a great sense of humor, both on and off the bench. So today I urge you to vote in her favor again, because if confirmed, I am confident that she will bring those same qualities I just described to the Supreme Judicial Court. She will, of course, be in a different position and able to do more for the citizens of the Commonwealth on the SJC than she has been able to do on the appeals court. The justices of the Supreme Judicial Court can change precedent, interpret and reinterpret the statutes and our state constitution. They have the last word in many ways. That is an awesome responsibility. And I, for one, know I speak for myself and many others that I would like to see that responsibility in the hands of a jurist like Justice Wendlandt. She will bring her life experiences, of which you will hear more about later today, and her education to the job. She will be fair and open-minded and will only make changes when justice demands it. Now, in preparing for today's hearing, I listened to the audio recording of Justice Wendlandt's hearing back in May of 2017. And I was struck by how much what was said about her then still rings true today and will continue to do so in the future. Counsels, you may remember that Judge Walker of the Second Circuit Court of Appeals told you that she would be ready to go on day one. Well, she was. And she will be prepared to do the same thing on the SJC if confirmed. You heard that she was a team player. Well, she is. And she will be the same team player on the SJC. You also heard at that time from Attorney Joan Lukey, whom you will hear from again this morning. And she told you about Justice Wendlandt's incredible work ethic. Well, since joining the court, she has published 31 decisions. The count was only 30 at the press conference a couple of weeks ago when she was introduced by the governor and the lieutenant governor. But just this past Monday, another fine decision was released by the reporter's office, authored by Justice Wendlandt. Goes to show she's not slacking off one tiny bit before she leaves the appeals court. But the real numbers are much higher. The majority of our decisions are unpublished. So I estimate that Justice Wendlandt has written about 170 decisions and has participated in resolving approximately 600 cases. In addition, she has taken on extra work by serving on numerous committees, both within and outside the court. Inside the court, she's a leader on our case management committee, our policy and procedures committee, our IT steering committee, just to name a few. But maybe even more significantly, she has taken the time and the initiative to visit the various trial courts throughout the Commonwealth. In fact, I first met Justice Wendlandt when she traveled to Springfield to visit the district court, even before you confirmed her nomination to the appeals court. Her quest to understand the day-to-day issues facing the trial courts has not abated. She is our liaison to the probate and family court, and she's observed proceedings in the housing court, the land court, the BMC, as well as other district courts and superior courts throughout the Commonwealth. My point here is this. Justice Wendlandt is the same intelligent, energetic person you confirmed 3 years ago, and now she's even more experienced. She has reviewed decisions, hundreds of them, from all 7 trial court departments and the administrative agencies of the Commonwealth. She is fully prepared to be elevated to the Supreme Judicial Court. I will conclude by saying that this nomination is bittersweet. If confirmed, Justice Wendlandt will be sorely missed. She has been a tremendous asset to the appeals court. But we are thrilled for her, and like her family, we are very proud of her accomplishments. Now, I know my time is just about up, but I would like to make one final observation. Last week, Justice Geraldine Hines, a true trailblazer, the first Black woman to serve on the appeals court and the Supreme Judicial Court, spoke so eloquently about the historic nature of the governor's nomination of Justice Kimberly to be Chief Justice of the SJC. Another exceptional nomination. And how fitting is it that on that very same day, the Supreme Judicial Court held a special sitting to honor Justice Ruth Abrams, the first woman to serve on the SJC. And now this body has the opportunity to make yet another historic commitment. Justice Wendlandt is the second Latina to serve on the appeals court. Our friend and colleague, Justice Diana Maldonado, who has had a stellar judicial career, was the first. But if confirmed, she will be the first Latina to serve on the highest court of the Commonwealth. She is exceedingly qualified to do so. I hope you confirm her nomination and we continue to see cracks in the proverbial glass ceiling of the John Adams Courthouse. Thank you for your time. Thank you all your counselors and Lieutenant Governor for all of your work on behalf of the citizens of the Commonwealth of Massachusetts.
Thank you, Justice Fuono, and thank you for your service to the people of this Commonwealth. Obviously, your words are powerful in that you've observed your colleague and her work.
I have.
Obviously, in these past few years. And it's also a bittersweet moment as you wish her to continue in her service to the Commonwealth on another court. And I'm sure you'll miss her immediate presence on the court with you. Having said that, I know the counselors do have some questions. We'll start with Counselor Duff.
Thank you. Thank you, Judge. I appreciate it. I do want to set the record straight that I was on the council when she came before us, and I did vote for her.
Well, thank you very much for setting that straight. I won't trust internet research again.
That's all right. Thank you for your testimony.
Counselor Devaney.
Welcome back. I just wanted to ask you, what do you think is the most outstanding attribute that this nominee has to bring to the Supreme Judicial Court?
Her intellect. She's one of the smartest people I know. Her intellect combined with her compassion. Those two things are a recipe for success in my book.
Okay. Thank you very much. Thank you for coming.
Counselor Ferreira or Counselor Hurley, do you have any questions for the witness?
I do not. Thanks, Governor.
Okay. Okay. Thank you very much, Justice Fuono. Thank you.
Thank you.
We will now hear from the Chief Justice of the Probate and Family Court, the Honorable John Casey, who is in person and will present his testimony. Welcome.
Well, good morning.
Good morning.
I am John Casey, the Chief Justice of the Probate and Family Court Department. I am honored today to testify on behalf of the nomination of Justice Dalila Wendlandt to serve on the Supreme Judicial Court. Nearly 14 years ago, I sat before this body seeking confirmation for Associate Justice position in the Probate and Family Court. At that time, I never would have imagined that I would become Chief Justice of the Probate and Family Court and be asked to speak on behalf of a nominee of this caliber to the most respected appellate court in the country. But being in this position as chief, you meet some extraordinary people, such as this nominee, who have chosen, like you, to be public servants serving the greater good. So I'd like to share with you some of my impressions of Justice Wendlandt since I met her in 2018 when I became chief and she became the appeals court liaison of the Probate and Family Court. I'd only been chief for a short time before preparing to address our fall conference, judicial conference. Part of my responsibility was to introduce Chief Justice Gantz, Chief Justice Carey, Court Administrator Williams, and Justice Wendlandt. I knew the first three quite well, but I had to do some research to properly introduce our new liaison. It did not take long for me to realize that the justice was extremely accomplished. MIT, Stanford Law, Ropes and Gray. Her first case as an associate was before the United States Supreme Court. I think mine was a speeding ticket for a neighbor of mine. Honestly, the more I read, the more intimidated I became. When we first spoke, however, I found Justice Wendlandt to be warm, welcoming, friendly, kind, and truly down to earth. I was impressed by how interested she was in learning about the Probate and Family Court. She asked questions that demonstrated that she had researched the jurisdiction of the Probate and Family Court, but perhaps more importantly, the work of the court. The breadth of her questions made it perfectly clear to me that Justice Wendlandt took this role seriously and wanted to know as much about our court as she could. She's attended every judicial conference that we've had since she became our liaison. Conference topics, which included how to handle sexual abuse allegations, removal of guardians for minors, alimony in the tax code, the impact of poverty and homelessness in our courts, and she was well received by all of our judges at each conference. At a spring 2019 conference, Justice Wendlandt conducted the Appellate Year and Review panel with Chief Justice Gantz, discussing published decisions from the Probate and Family Court that have been decided by the Supreme Judicial Court and the Appeals Court. As you can imagine, it was an engaging panel. I think it's important to note that it's not always easy for judges to hear why an appellate court thought a trial judge was wrong. Justice Wendlandt's presentation was balanced and instructive. She speaks confidently, but without airs. It was clear to my judges that she viewed us all as one judicial system working together for justice for all. To learn more about what it's like to be a trial judge in the Probate and Family Court, Justice Wendlandt was part of a delegation of appeals court judges that observed Judge Linda Fidnick during a session of the Family Resolution Specialty Court in Northampton, referred to as Frisk. This court allows Judge Fidnick to assist eligible families to improve their communication and parenting by removing the adversarial component and providing additional resources like a mental health professional and counsel for the children. Judge Fidnick was struck by how open Justice Wendlandt was to the concept of this specialty court, immediately understanding that the needs of these parents were different from other types of litigants in the traditional judicial process, and appreciating the availability of obvious yet critical resources to these families. She inquired about due process protections, asking how the record was preserved should there be an appeal, and about the consent signed by the parents. Judge Fidnick wrote to me following the nomination and said that one short afternoon, Justice Wendlandt, who had never sat in family court, had been a lawyer who handled family law cases, grasped our entire universe. The tragedy of divorce and separation for both parents and children, the awkward fit of these cases in the traditional litigation process, and the ways in which the court seeks to meet those needs within the context and with the protections afforded by our judicial system. Judge Fidnick wrote, "She was that rare and amazing combination of intellectually brilliant and emotionally astute." I cannot agree more with Judge Fidnick. For me personally, when I've spoken to Justice Wendlandt about concerns that judges have raised about various issues, like the tone of an appeals court decision, for example, she listened, asked questions, and followed through. On occasion, she would call me and ask a non-case specific question related to the Probate and Family Court, and we would talk about it, always with the goal of making the work of both courts better. I have been grateful for the open communication that we have had. Being a justice of the Supreme Judicial Court requires thoughtfulness, thoroughness, patience, collaboration, and a desire to improve the law for the citizens of this Commonwealth. I believe Justice Wendlandt has all these qualities and would be an excellent justice at the Supreme Judicial Court. I wholeheartedly support her and support this nomination. Thank you, Lieutenant Governor, councilors, for this opportunity to appear before you this morning.
Thank you, Chief Casey, for your heartfelt testimony on behalf of our nominee. Questions on the councilors, Councilor Iannella.
Good morning, Chief.
Good morning, Councilor.
It's good to see you.
Nice to see
I think you're doing an outstanding job as the chief of the Probate Family Court. I think you're doing a great job. Can you just give us all a status as to when you expect, if they haven't already, trials in the probate court? I know there's they're doing the Zoom on motions, pretrial conferences, but if you can give us some type of suggestion as to when you think the trials will begin.
Yeah, thank you for that question, Coach, and thank you for those kind comments. We've got tremendous staff that have worked through these challenging period of time. So a number of months ago, we began conducting trials in the court. And I think the reality is that very few people want to come into court. And so they're opting for a virtual hearing instead. But we are affording them the right to come in person and have a trial in the court. We've done, the trial court's done a great job of making certain that the courthouses themselves are safe with proper PPE. And there's just, I think there's been a hesitation on the part of a number of people to come into court, including lawyers. But we're open for business. We have been for a period of time. I can frankly again say that there have not been a lot of in-person hearings, but that's not because it hasn't been an option.
No, I understand that, but can you give me a sense when you think, and I know is it a year, 6 months? Do you have any sense when you think in-person trials will begin? Are we talking a year from now? And I know you're not going to know exactly, but you must have some sense.
Well, they already have begun, frankly.
No, but I'm talking if somebody does not want to go to the courthouse and they don't want to do it virtually. In other words, when's it going to be mandatory? Hey, you got to show up.
Yeah, I don't mean this. I guess it will follow the science, and I think that when things get improved, when things improve, then I think more people will be willing to come into court. But again, it's judges are in a difficult position. I mean, if someone has a reasonable basis for being concerned about their health and safety, it's a decision made by each judge, but they don't want to jeopardize someone's life by forcing them to come in for a trial.
And I totally agree. I mean, if it was me, if someone asked me that question, I'd say, hey, it could be another year. That's what I was trying to get if you had some sense, but but I mean, you can, we're in the surge. It's not going to get over this COVID tomorrow. I know the vaccine obviously is coming, but if somebody asked me that question, I'd say, geez, I don't know, maybe at least another year. It's going to be a while, I assume.
Yeah, I hope it's sooner than that, frankly. I hope it's, I'd love July 1st to be a situation where, things are much better and people feel more comfortable coming into court and people don't have a reasonable basis for not coming into court. But again, that's just my guess.
Thank you very much. Appreciate it.
You're welcome.
Councilor Jubinville?
Sorry.
Nice to see you, Chief. I share the sentiments of Councilor Ionella. I think you're doing a great job as Chief. Let me follow up on that question. Is there a need, because of what we've learned because of this pandemic, is there a need to ever have trials in person in the probate court?
Thank you for your kind words. Having sat as a trial judge for 12 years and having conducted Zoom hearings, evidentiary hearings, we've done a good job of trying to replicate the experience, but I think there's still, there's nothing like having an in-person trial where you can make observations of the parties. So I think that you didn't ask this question, but I think a lot of what we do, we can do remotely. We're working very hard in trying to identify matters that we can handle administratively so that there'll be less people coming into the courthouse. But I think that it's such an important matter to have a trial and the issues that we deal with in our court in terms of removal, in terms of custody, that I think that when we're safe to do so, I think that those matters will return for hearings in person in our court.
Yeah, I agree. I think it's hard to get an assessment on somebody's testimony over video. Sometimes it doesn't even sync up with the movement of the lips. So I think that would, for a fact finder like a judge, that would impede you getting a sense of who's telling the truth and who isn't.
Yes.
But I suppose a lot of hearings you do in the probate court can be done. I know in the district court, and superior court, I see the future for a lot of appearances, pretrial conferences, which take 5 minutes sometimes. Now they're being done on Zoom. Lawyers aren't running all over the state to show up in courts and being late and so forth. So I think that's going to happen. I'm going to ask the nominee also about the appeals court and the SJC about remote issues. Let me ask you, is there a backlog now because of the pandemic in the probate courts?
Yes. Yes. Frankly, with the governor's assistant, we brought back 2 recall judges to help us with the backlog of child support cases with the Department of Revenue. We've been working since late March with the department and again with the governor's office. And we have, again, these 2 recall judges now. And we've got the backlog is probably down to less than 1,000 cases. And in terms of, it's hard to tell exactly what the backlog is in every single division. We have individual calendars, so every judge is responsible for their own calendar. But anecdotally, obviously it's taking longer for people to have hearings. It's taking longer for them to get pretrial conferences. And if I can just go back to the point that you made, Councilor, it's a silver lining, I guess, that people have embraced the remote hearings for temporary orders, for example, or pretrials, because they don't have to drive, an hour and a half to get to the court. They don't have to look for parking. They don't have to get childcare. They don't have to get elder care. They don't have to leave work sometimes. So it's really been so much more convenient for them. And I never thought I'd see a day where we'd be doing that. And the lawyers have embraced it also. We were very worried about lawyers and how are they going to stay in business and how are they going to represent their clients. And so this is really, it's really, it's been a very positive result. And again, we have the technology now so that for the most part, that we can operate almost totally remotely. And that's what our goal is, to be prepared for that, just in case.
Yeah, I love going to courts and I love doing what we do in courts. I also like the socialization going to court. So I had 2 weeks back, I had three different courts to go to, one down the Cape, one in Boston, and one in Lowell. And before the pandemic, I would have been going to those 3 courts, calling each court, telling them I'm going to be late, probably getting to one of them at 2 o'clock. I sat in my office and did all 3 of them in an hour.
Right.
But I miss going to court too, so that's the trade-off on it.
Right, and we have worked with the law schools because they all have clinical programs, and they were concerned, and we were concerned that these young law students about to become lawyers would miss out on that opportunity of being in a courtroom, observing what went on, observing the judges and the lawyers. So we made sure that they have access to all Zoom hearings so that they can participate at least in that fashion by watching what goes on. I know it's not the same, but we're sensitive to that issue. You do learn a lot by being in court.
Well, you learn, you sit in courtrooms with other lawyers and you learn about this particular judge who's on the bench and
right.
certain characteristics as to the judge on the bench. So you kind of learn the routine that way.
Right.
So I miss that. Maybe that will come back someday, but I do find, especially in the district and Superior, they are offering lawyers can go to court if you wish. If you don't wish to have Zoom, you can go to court. But I noticed the courts are really, like this morning I was in Quincy Court and it's like a morgue. I mean, there's hardly anybody in there. The halls are empty. It's a completely different feeling. But we'll survive it and we'll continue on and we'll make it. Thank you for your testimony. Your testimony means a lot to me today on behalf of the nominee.
You're welcome.
Councilor Devaney?
Thank you. Nice to see you again.
Nice to see you.
How many years has it been now when you first came before us?
Almost 14, be 14 the end of this month.
Wow. So
like
it was
yesterday.
Councilor Iannella and myself that proudly voted for you. I'm pleased that you are the Chief Justice. This court is so sensitive, and I think of it in the pandemic, and I've said it so often, I've said it publicly here. I'm concerned about child abuse. How do we track that in this terrible times that we're going through? you have cases.
Yeah, you're absolutely right. I think we've all been concerned about, that when children aren't able to go to school and be observed by teachers or school nurses, those type of issues. It's a major concern for all of us. We have meetings bi-weekly now with the Access to Justice Commission, and we talk with them about ways to ensure that people that may be in abusive relationships or children that may be exposed, that they will have a safe access to our court, because a lot of times they're living in that environment with the abuser. So we're sensitive to it. We're trying to work with that. We're trying to do the best we can about that.
Well, our society has changed so much that someone in your position 30 years ago didn't have to deal with these things. I mean, I just heard in the news a 2-year-old was found dead in a car. I mean, we hear all of these horrific things all the time. And you mentioned school. Well, for school-age children, we would have the ability when they went to school that maybe they talked to a teacher, maybe they had a scratch or a bruise or something. And so I'm really concerned about how we do that. Now, how many trials do you think you're behind now?
Well, I think it's hard to put a number on it, but I think that it may be taking 2 months, 3 months longer to get a trial date than it did beforehand, and that's problematic. But it takes so much longer to do the work that we do now. The judges are saying it's roughly you can do about 25% of the work remotely.
Wow.
So if before we could handle 40 cases in a day, you can do 10 or 12 with the hearing. So it's really, that's why I mentioned to Councilor Jubenville that we're really trying to identify matters that maybe don't have to go before a judge, that can be handled administratively, so that we can focus on the important cases where there are allegations that you mentioned.
No, I was thinking you can't even send anyone out there to someone's home to see if everything is going right and people are doing the right thing. I talked to Michael Sullivan from Woburn, and he told me they have missed 1,800 trials. I mean, how long would it take to get through that backlog? And that's not bench trials. So, yeah, I am concerned about you going through, and I'm so glad you're there. I thank you. Now, while you're here, I want to ask you, what interaction have you had with the nominee, and can you tell us about that?
Sure. So as I mentioned, again, I haven't known her for a long time, but I've known her these past 2+ years since I've been the chief. And again, each chief justice appoints a liaison to each department. And we're fortunate enough that Justice Wendlandt was assigned to our court, and she jumped right in. And so she would be at the conferences. We have a fall conference that's 1 day. We have a spring conference that's 2 days. So, she was one of the few non-probate and family court judges who would be in that setting, and we would spend, the entire day there. And I recall her, I think the first time, just raising her hand, asking a question during one of the conferences. She made it a point to meet every single judge that was there. She followed up if she had questions, like I say, on her own initiative. You heard how much work she's done and how much writing she's done and reading. On her own initiative, she reached out, and I had it in my remarks, but I cut it because of time. But, she invited Judge Basinius from our court to come to the appeals court educational conference and talk about what's it like, what's a day in a life like for a judge in the probate and family court. As I mentioned, she's just, you look at her resume, and honestly, it's so impressive. And you meet her, and she's so impressive, but she's so kind, and she's just so easy to talk with. So I felt comfortable when, as I mentioned, there are times when there's a bit of tension between the appellate courts and the trial courts. We're all human and sensitive, and so when I had those discussions with her, she listened, and again, I felt that she was generally going to take steps to try to make things better.
Well, I have always said that when I vote for someone, they have to have compassion and empathy, or they don't get my vote. And I'm so proud. Besides your qualifications, that's why I voted for you. And I have to say, and I'm not trying to massage you, but you haven't changed that much in those years. So whatever you're doing, keep it up. But thank you for coming. Your testimony means a lot, because I'll tell you, in the past, sometimes we've had a nominee, and I'll say, what interaction? How do you know this person? One case maybe they saw in court. So you know her personally and professionally, and that's the greatest testimony that the council can get. So thank you for coming. I really appreciate it.
You're
Thank you.
welcome.
Other members of the council?
Governor?
Hey, Governor.
Councilor Hurley?
Judge, have the number of filings since COVID increased, or has there been a decrease?
Well, good morning, Judge, and good morning, Counselor. The filings have decreased, and they haven't increased as significantly as we thought they would have.
Do you know what is the bottom line for that?
So again, I get the filing report every single week, and when this hit, in late March or so, our filings went down to probably 5 or 10% of what they had been the previous year. And now they run roughly between 50 and 70% of what was filed previously. And I could speculate as to why. I'm not sure exactly why. I think a lot of it has to do with the Bar Association, the lawyers. I think that they have really problem solved. I think they've worked. I think that, honestly, I think that people have, this COVID pandemic, I think, has caused people to reflect perhaps on their situation and maybe reconsider staying together or not taking action in the court.
Well, maybe that's a bright side to the COVID situation. I just hope that there's no pent up massive filings when things get back to the new normal. Thank you for your service.
You're welcome. Thank you.
Councilor Ferreira?
Thank you, Governor. Always nice to see you, Judge, and I'm always proud to mention that you're from Bristol County, of course. You're doing a great job. I was going to ask you about the holdups, and the only complaint that I hear from parents who are trying to get into court, haven't seen their kids in a month or two, and are told that they don't have a date for 2 or 3 months out. But you address that, and I'm wondering if there's any way to make that better, like you said. And I've talked to our registered probate, who I think is great, Tom Hoy, and he says that judges have 10 or 12 slots a day instead of having 45 hearings I could talk about. They're doing 10 or 12 a day, and people aren't getting into court to see their children for months at a time, which is heartbreaking to me. And I'm just wondering if there's any way we can expedite that and put more hearings on, or you need more judges, more Zoom conferences, more equipment. I don't know what the answer is.
Yeah, thank you, Council. It's nice to see you as well. And that's not good for me to hear that. One of the main challenges I've had as chief during this period of time is I don't always know exactly what's happening in each individual court. We've got 51 judges, we have 14 divisions, and we have tried to support the divisions. I know that they're working incredibly hard. When we were closed for 2 days, and our staff was so upset because they knew people needed our help. So they've been working every day since then, in late March, and we created virtual registries so that we have hundreds of people a day who are having questions answered, having forms filled out, paying fees, all done remotely. We have a lawyer of the day programs that are run through those virtual registries so people can get that kind of help. And again, I'll follow through, and I'll get back to you, Council, on what each division is doing to try to focus on those type of cases. Those are the matters that, the judges are trying to focus on. Anything to do with custody or, for example, a contempt, if someone's being denied parenting time. those are supposed to be given priority as much as possible. So I'll look into it and see what the numbers tell me. I'm sure what you're saying is accurate. And, I think it's just a matter of there's only so much time in the day, and there's so much staff that we have, and we just need to prioritize those type of cases. That's why I said we're trying to do other matters administratively. We have taken all the Department of Revenue cases out of the divisions to free them up. That's why I handled it for about a month. We had recall judges handling it, so that we could free the judges up to hear those type of cases.
Right. And, you know, I want to be clear. I know that at least in Bristol County, 100% of the workers are showing up every day and working as hard as they can, and your staff's working every day as hard as you can. And I just wonder if there's a technology issue, or you just need more resources for, you know, maybe recall judges or something like that to make it happen.
Yeah, that's, thank you. Yeah, we'll continue to look at that and see what we can do to improve the situation.
Well, thanks, Chief. I appreciate all your service, and I wish you the best.
Thank you.
Thank you, sir.
Thank you, Councilor. Thank you, Chief, for your testimony this morning on behalf of our nominee and for the update to all of us. I know how difficult these times are, and we appreciate you and your staff for working through these challenging issues, and we'll continue to work with you to provide the service needed for the people who frequent your court. Thank you.
Thank you, Lieutenant Governor. Thank you, councilors.
Our next witness is on WebEx, and she is a colleague of Justice Wendlandt's from her days at Ropes and Gray, and is currently the practice leader for complex trial and appellate litigation at Choate Hall & Stewart. Attorney Joan Lukey, welcome, and thank you for your testimony this morning.
Thank you very much, Madam Lieutenant Governor, and thank you to the governor's counselors for this opportunity to speak to you today about someone whom I respect deeply and cherish even more deeply as a friend. You all heard back when I testified when she was nominated for the appeals court, but we have been friends and we're law partners starting in 2008. Let me begin by saying a few words about Dalila as a practicing lawyer, just to refresh your memory, although I'm sure none of you has forgotten. She was the go-to person in intellectual property litigation at Ropes and Gray when I arrived, but she was also a person whom we all turned to with judgment calls and complex issues. For me, in the civil commercial litigation area, less specific than intellectual property litigation, I knew I could always count on Dalila to have the right insight into the proper approach in a case. She had comprehensive knowledge, not just of her own area, but of civil litigation generally. And that's an important topic because a great majority, I believe, of our cases, at least in the Superior Court level, are in fact on the civil side, which is not in any way to say that the criminal side is not critically important as well. But her insight as a civil litigator, I would respectfully suggest, has been extremely helpful to her work on the appeals court and will be equally so if you give her the opportunity to serve on the Supreme Judicial Court, as I sincerely hope that you will. Her judgment and her intellect have been mentioned by other witnesses preceding me, and they are beyond question. She was the quintessential civil commercial litigator, particularly in the intellectual property area. But having said that, I'd actually like to address my comments now before I close, because I know that our time is to be limited, to Dalila Wendlandt as a person, because that's why she's so dear to my heart. I believe that great jurists are not simply great legal intellects, although that's obviously very important, but they also have to be compassionate and truly good human beings. And that's what Dalila epitomizes. At Ropes, she was known for her tremendous personal traits. Just as we have heard, she has been known for the same things on the appeals court. Her personal traits set her apart, in particular because of the degree to which she demonstrated them. She was dedicated to Jeff and her kids, and she showed an uncanny ability to balance the needs of her family with the needs of her clients and, yes, of her friends. She did all of that, always seemingly totally unruffled by what she confronted. But most of all, Dalila was known for her generosity of spirit. I can't really even describe to you how important that can be when you function with a colleague like Dalila in a high-stress legal practice setting, as we did. But to me, generosity of spirit means that she was willing to share all of the gifts that she had and that I've mentioned, that other witnesses have mentioned to you, with others, with absolutely no expectation of repayment of any kind. I'm not sure in my entire life I have known more than a handful of people who brought to the table the kind of generosity of spirit that Dalila does. And I can tell you, as someone who stands on the advocate side and looks up at the people on the bench, that generosity of spirit and compassion are extremely important, not really for us as advocates, although that's always nice, but for our clients. Because every client who comes into a courtroom, every party who crosses the threshold of a courtroom, be it trial or appellate in the Commonwealth of Massachusetts, should be entitled to a compassionate response demonstrated with the generosity of spirit that a person like Dalila Wendlandt brings to the table. She excelled as a lawyer, yes, but she excelled even more as a person. And I will point out that at Ropes and Gray, she did so coming from a non-traditional background, particularly back then. She did so in a way that showed that she was able to overcome stereotypes and traditional beliefs about lawyers and people in the courtroom. She came to us as a Latina and as a woman in a time when there were few of either at the top of the profession. She rose to the very top, and now she appears before you. We are hoping that you give her the opportunity to rise to the very top again. The Supreme Judicial Court is one of the greatest and oldest continuously functioning courts in the Commonwealth. I can't imagine anyone I would be prouder to see there, or anyone who I think would do a better job for the people of the Commonwealth than Justice Dalila Wendlandt. And so I ask you to give her your positive consideration, and I'll be glad to answer any questions you have. And again, I thank you for the opportunity to come back to you again to tell you how important I believe Justice Wendlandt is to the Commonwealth. Thank you.
Thank you, Attorney Lukey, for your comments, both relative to the professional experience that Justice Wendlandt has brought through her career, as well as her personal attributes. Councillor Duff.
Thank you. Nice to see you again, Attorney Lukey.
Thank you. Nice to see you.
And thank you for this great testimony. It's very meaningful, as you are a legend as a civil litigator. And I would like to actually take this opportunity to thank you for your broad shoulders, because a lot of women and a lot of people of different diverse backgrounds stand on your shoulders. You have been an amazing advocate, sometimes in front of the scenes, but very often behind the scenes, for diversity in law firms and for diversity on the bench. And I just wanted to take this opportunity to acknowledge it and to let you know it has not gone unnoticed. I know you have championed many women of diverse backgrounds, and I, for one, deeply appreciate it. Thank you.
Thank you. Thank you very much, Councilor Duff.
Well stated, Councillor Duff. Councillor Kennedy.
Thank you for your testimony. It's greatly appreciated. It's some of the observations that you've made, I've made over the last few years of her as she sat on the appeals court. Your testimony certainly means a lot to me as well. I appreciate it. Thank you.
Thank you.
Councillor Hurley.
Nice closing. Thank you.
Thank you. Thank you, Councillor Hurley.
Okay, thank you, Attorney Lukey. It was an honor to have you with us this morning.
Thank you.
I'd now like to recognize Attorney Anne Marie Bellevue. She's an attorney with Ropes and Gray and former law clerk to Justice Wendlandt, and she is here in person. And welcome. We're pleased to have you today.
Right, thank you. Good morning. My name is Anne Marie Bellevue, and today I have the honor and privilege of sharing a few words about Judge Wendlandt. I want to start by first thanking Lieutenant Governor Polito and the governor's counselors for providing me with this opportunity today. I want to also thank Judge Wendlandt for asking me to be here. I hail originally from Ottawa, Ontario, Canada, and after having completed my undergraduate degree in Global Development Studies and my Master's of Arts degree in Dispute Resolution in Canada, I moved to Boston in 2015 to attend Suffolk University Law School. I clerked for Judge Wendlandt for the 2018-2019 court term after having graduated from Suffolk. I am now a corporate associate at Ropes and Gray here in Boston and could not be happier to have made Massachusetts my adopted home. Having the opportunity to begin my legal career as Judge Wendlandt's law clerk has been and always will be a true blessing. Having never met one another prior to my clerkship interview, once we did meet, I knew that if selected, we would get along swimmingly. I knew this because during my interview, Judge Wendlandt showed more interest in my writing sample law review note topic, a comparative law piece, than anyone else I had ever discussed my note with up until that point. Like with my note topic and everything else, Judge Wendlandt always took a keen, genuine, and dedicated interest in my growth and development, not only as a law clerk, but as a person. This amount of true kindness and interest she has always shown to me is not unique. Rather, it is in Judge Wendlandt's nature and how she would treat and interact with anyone before her. This is one of the main reasons I know that she will make an excellent justice on the Supreme Judicial Court. Next, I would like to share a bit of what it was like getting to work with Judge Wendlandt in her chambers. What I look back to most fondly of my time clerking for Judge Wendlandt are our impromptu story times. I would always have the best intentions when I entered Judge Wendlandt's chambers of asking my legal questions in a clear and succinct way, and then leaving Judge Wendlandt to her day and her many obligations as a very busy appeals court judge. Something always happened, however, where things would not go quite as planned. We would end up discussing the law, of course. Judge Wendlandt would naturally resolve all my outstanding questions, but then instead of turning back towards my desk right away, our conversations would always flow naturally and lead to stories about our lives, childhoods, adventures we've taken, and challenges we have each faced. I remember one late Friday afternoon fondly, where I went to Judge Wendlandt's chambers to discuss, as per usual, something case-related. I emerged what was truly hours later, having entered Judge Wendlandt's chambers in daylight and having left when it was dark out. It is truly a surprise to me how Judge Wendlandt managed to be such an effective appeals court judge with me taking up so much of her precious time. I believe that no matter who you are, however, Judge Wendlandt is always incredibly generous with her time. Being in Judge Wendlandt's presence, one always feels both truly seen and heard. I am confident that these innate skills of Judge Wendlandt's will be of great value as a Supreme Court justice. Getting along so well on a personal level, I believe strengthened the quality of the work that we were able to accomplish together as judge and law clerk. It goes without saying that Judge Wendlandt is an excellent writer with an unparalleled legal mind, and I will always be grateful that I was able to play a role in her writing process. Being in Judge Wendlandt's chambers is like being part of a team. And although I may have been, and always will be in every way, the rookie in our two-person team, she always had a way of making me feel like the most valuable player each and every day. I have nothing but pure confidence that Judge Wendlandt will make a stellar addition to the Supreme Judicial Court, and that her contributions to all Massachusetts residents in her new role will be deep and meaningful. Thank you for allowing me the opportunity to share a few words with you all today about Judge Wendlandt, who without a doubt has been one of my biggest mentors in both my life and legal career. It has been both an honor and a privilege to be able to be here today and to contribute to the outpouring of support that Judge Wendlandt has received in her historic nomination. Thank you.
Thank you, Attorney Bellevue. It was very special to share something that is out of public view, but particularly compelling about our nominee and how she conducts herself when people aren't looking, and how important it has been to your career and personal development. So the power of role models and mentorships is well stated from your words, and thank you for acknowledging that. Questions from the counselors? Counselor Hurley.
Thank you for your presentation. I'm curious, how were you chosen to serve as a law clerk? What was the process?
So for the interview process, I was chosen. First, you apply not to a specific judge, but to the appeals court. And then the appeals court does an initial round of interviews, like a screening interview. And then you go through a process. And then I think judges, there's a seniority process that judges follow in order to select from a pool of candidates that are previously screened through an interview process. And then you get to interview with individual judges.
So you must have done just as good a job there as you did today. Thank you.
Thank you.
Any other questions? Okay. Thank you very much for your presence today.
Thank you.
We appreciate it. Is there anyone else, either in person or through WebEx, that would like to be heard in favor of Justice Wendlandt? Okay. Hearing none, we do have some letters of support that we would like to acknowledge. I know Councilor Duff has also a letter she would like to read into the record. First, a letter of support in favor of Justice Wendlandt's nomination from the Massachusetts Black Judges Conference, and in part it reads, Justice Wendlandt's experience and expertise with the interplay between science, technology, and law brings a unique and invaluable perspective to 21st century jurisprudence. In the short time that Justice Wendlandt has been on the appeals court, she has proven herself to be an intellectual powerhouse with a healthy dose of humility. If confirmed, Justice Wendlandt will bring an important and distinct perspective to the Supreme Judicial Court that will enrich the court's deliberations. The citizens of the Commonwealth deserve the opportunity to have Justice Wendlandt sit on their highest court, making her the first Latinx justice on the Supreme Judicial Court. That letter has been shared with members of the council as part of your record. Councilor Duff.
Thank you, Lieutenant Governor. I usually don't like to take the time to read letters, but I think this is quite compelling. It's from Attorney Jane Willis at Ropes and Gray, counselors. I write to support the candidacy of Justice Dalila Wendlandt for the Supreme Judicial Court. I've known Justice Wendlandt for 23 years as a fellow associate and then fellow partner in the litigation department at Ropes and Gray LLP. Of course, Justice Wendlandt is extremely smart and hardworking, but Justice Wendlandt's analytical skills and legal reasoning skills are at the very top of the profession, honed by her clerkship with Judge Walker and her practice alongside and across from some of the top litigators in Massachusetts and across the U.S. As you are likely aware, civility in the litigation side of the legal profession has arguably been on the decline for many years. In private practice, Judge Wendlandt has held herself and all around her to a very high standard, not just civility, but kindness with opposing counsel, clients, judges, and court staff. She expects the best of herself and others around her. Within the Ropes and Gray community, she was an excellent firm citizen, taking on many roles beyond the pressing client work, including training, mentoring, and recruiting associates, including, but not limited to, racially and ethnically diverse associates, and participating in the operational side of a law firm. She was committed to pro bono work and exceeded the firm's and the profession's recommended number of pro bono hours each year. Notably, as a member of the firm, Wendlandt has always made time for her colleagues, no matter how busy she was, and was very kind and compassionate to all around her, including, for example, secretaries and mailroom personnel. I know directly from my conversations with Judge Wendlandt and those who practiced before her on that court, on the bench, that she is a good listener, is patient and compassionate with litigants, and particularly pro se civil litigants who do not always have a lawyer and may be facing difficult circumstances. There are many reasons why Judge Wendlandt will be an excellent member of the Supreme Judicial Court. These are just a few. I recognize that her colleagues on the Massachusetts Appeal Court and others with greater insight will point out additional compelling reasons. So thank you in advance for taking the time to read this short letter. Sincerely, Janie Willis. It's a very, very, I think, touching and important letter, and we will be submitting this into the official record of your hearing.
Thank you, Councilor Duff. We have also received a notice of a witness in opposition, and Dr. Esther Notho is here with us through WebEx, and we did swear you in to deliver your testimony today. You may present, Dr. Notho.
Let me start by making a correction. I'm not here to oppose or support the nomination. The purpose of my speaking at this hearing is to point out to the court the rampant illegal violations from the beginning of getting a not even legally existent mortgage all the way to when foreclosure occur. Good morning. I am Dr. Esther Notho from Beverly. Honorable Councillor Duff is my representative. I thank the Governor's Council for letting me testify. I am here because the entire area of our right to property, particularly as people of color, is supposed to get equal weight in our Constitution as life and liberty. However, between Massachusetts allowing non-judicial foreclosure and the lack of enforcement of our laws, the courts do not see the vast majority of illegalities. This is true in my case. For instance, where the illegalities started before day one, when I got the mortgage, through until when they are trying to foreclose on me many years later. The few times that the courts are involved, they do not review the illegalities that we are all experiencing. I got my mortgage in May of 2004. It was never a legal contract. It was a violation of the reverse redlining law. Let me tell you how I was induced into signing this never affordable mortgage. My young daughter and I were displaced from our home in Kenya. And when we got here, my priority was to provide her with a permanent home again. I was subsequently introduced to a company known as Option One. Their representative asked me for my personal and work details. I told them that I was a certified nurse's aide, earning slightly over $500 a week. The Option One representative was disappointed and asserted that I could never buy a home without a credit history of over 2 years. My earnings did not qualify to buy the home I wanted, which was listed for $495,000. Being a recent immigrant, I was unable to comprehend his assertions completely. I was oblivious regarding the purchasing real estate process in the United States. Unlike my experiences in Kenya, where homes such as mine would typically be purchased in full without the financing products that are more common here. In an attempt to show that I was creditworthy, I disclosed to the option 1 representative that I had a saving of about $100,000 in a Bank of America account. $86,000 of this money were proceeds from the said sale of my home in Kenya. And the remainder was savings from my nurse's aide's job. At that point, the broker, the realtor, everybody's attitude changed. The option 1 representative asked for a copy of my bank statement and suggested the available funds might provide an opportunity to qualify. Before the day's end, the representative called and advised me that option 1 had a new program that provided a special opportunity to get into a home that I could otherwise not afford. I was specifically advised of the benefit of a new adjustable rate loan product, a product that option 1 advised me would adjust up and down according to my financial situation during the course of the loan, especially that my monthly payments would increase if my wages increased, and that payments would decrease if I went through a hardship and was not earning as much. I clearly remember this advice and believed it was an incredible product and opportunity. I was also advised that I could utilize the money from the sale of my home in Kenya to make a certain down payment and place the remainder of the proceeds from my home in a bank and would allow direct monthly payments after that, which is what I did. They then offered me further help by having their own attorneys represent me at a discounted price in the closing on the purchase. They, the mortgage company, then prepared loan application paperwork, which is very legible. It was prepared on my behalf without my review, in which they misrepresented my monthly income as about $6,000 per month, which they incredibly inflated as I earned slightly more than $2,000 a month. Shortly after that, I was told that a loan closing was scheduled. I was subsequently picked up at my then residence by a woman and taken to an attorney's office where I was asked to sign many documents, many of which I had never seen nor had a chance to review before being directed to sign. This is the definition of predatory. Our reverse redlining law identifies both mortgages that are denied, but also mortgages that are given that are adverse to the homeowner's interest. It also identifies that the mortgagee shall not give such a mortgage. It points to discriminatory basis, either based on the geographical area where you live, or in my case, on individual discrimination. I am a person of color who moved into an area that was overwhelmingly white. And the mortgage company misrepresented my income by so much that I looked like a high-income borrower of color. Research data shows that people in my situation got the absolute worst mortgage characteristics, identified as high asset person of color compared to high asset white person. In my case, the broker only got the loan approved because they claimed that my income was $6,000 per month. I was a new immigrant working as a nurse's aide. it was a clear misrepresentation. Option 1 and its representatives wildly overvalued the property. I understand the loan to value ratio is the most critical characteristic to whether a loan is likely to be foreclosed or not. The mortgage was for $470,000 after a $25,000 down payment. The property tax records show that the real property was valued at $283,700,000 at the time. That mortgage was never affordable and was doomed to fail from the beginning. It could never have been affordable. It was never properly underwritten. I did not know any of this at the time. I took my apparently illegal contract seriously. So seriously because I thought that I had committed to paying for 30 years, that I worked 3 jobs for 5 years and literally destroyed my health trying to fulfill my obligation. On the other hand, option 1, my loan originator went out of business because of their predatory lending practices. Ladd Court first saw this mortgage in 2007 in an active marital service proceeding. The court just signed off that they were fine as claiming to have legal mortgage. The predatory loans and foreclosures of people of color had already rocketed in 2007. The Commissioner of Banks in Massachusetts and the federal authorities had been giving the lenders notices not to do loans like mine. There was plenty of information out there, but the Ladd Court judge just assumed that these loans were legitimate. Since then, the mortgage has been claimed to have gone 3 different paths, none of which are legally possible. The Ladd Court saw this mortgage again in 2016. And again, it did not assess whether the party claiming ownership could possibly be the mortgagee. The judge did not assess whether the party who filed the case had the right to be in front of the court. What I understand, I now understand that that is called standing. Therefore, they never even figured out that they didn't have jurisdiction to have the hearing. What I understand is called subject matter jurisdiction. The Ladd Court had been told in 2013 in the HSBC versus Matt decision for when people like me were denied the right to show up as a defendant because the Ladd Court case is only for active military service. The SJC told the Ladd Court judges that each had on their own to assess whether the plaintiffs had standing. Clearly, none of these paths laid out for how to present supposed mortgagee could have acquired this mortgage. However, the judge never checked it out. I wasn't allowed to participate. Thank goodness I met the mutual aid network supported by the Mass Alliance Against Predatory Lending. My community showed up to protest the illegal foreclosure of my home. We found out I had actually stopped the foreclosure because I put an affidavit in the registry of deeds, which only laid out one of the many legal violations included in the mortgage. I'm now trying to do my case by myself without representation. I am scared. I have learned a ton, and I know that what was done was illegal. I need to know that the judges will hear me equally and take seriously our laws that should have protected me from day one from this industry's structurally racist practices. I need to know that the judges who are being confirmed for the SJC will give equal weight, if not more weight, to those of us who have lived through this nightmare. Our affidavits are on personal knowledge and legal understanding. We have had to learn the real law behind this stuff. We need the judges to learn that too. We need the judges to enforce the plaintiffs who don't legally exist in many of these securitized trusts, don't legally have our mortgages. We don't even have legal mortgages at all if the origination issues were looked into. We need the judges to take seriously that they will not assume that a lawyer for the bank, when they represent something that is supposed to be an affidavit, such as recorded on my property, is an actual affidavit. Anybody who can look at it and see that the person swearing to it has no personal knowledge of what happened, that person also has no business knowledge because they are swearing for a company they don't even work for. My affidavit has to be on personal knowledge. Why aren't these companies' affidavits recorded to be on personal knowledge too? I don't have anybody else to swear to any of this stuff or know what happened to me. Please, please. If you are confirming judges, make sure that they know this law. Over 100,000 households have been directly foreclosed. They are tenants' households that have lost their homes. I don't want to be one of them, but it will not work unless the courts are enforcing our laws. Thank you for listening. Good morning.
Good morning, and thank you very much for your articulate presentation and sharing your circumstances. You not only speak for yourself, but for many others who can benefit from your sharing your circumstances. Councilor Duff.
Thank you. Good to see you, Doctor. We know each other and we've spoken about this in the past. I want to let you know that we hear you and we see you and we understand this issue is of greater current need than perhaps the council was aware of. We did meet last week with some of the governor's legal counsel and Justice Budd, who may be confirmed today, and the issue is being taken quite seriously. We are willing to do our part to educate our land court judges better on this issue. It is a very, as you know, it is a very, very complicated issue of law, and none of our land court justices are approaching these cases with malice. The law is very, very complicated and not something that we have frankly dealt with as much as we are right now, and I fear we will be going forward, frankly. So thank you for your testimony. We hear you, and I think we have all, I will speak collectively for the council, and they can certainly tell me whether I'm wrong, but I think I collectively speak for them that we are taking this quite seriously, as is the bench. And the issue is going to be addressed as best we can, and I think a lot of that is through education. So thank you again.
Thank you.
Okay, Councilor Hurley.
I just wanted to point out that the Governor's Council is a good place to start, but a lot of this has to do with reforms in the legislature. And I hope that the Alliance is working on that, along with what hopefully Justice Budd and the rest of the members of the Supreme Court will do as it relates to this issue. I'm sorry it happened to you. I'm sorry it happened to anybody. And it's not the kind of thing that the common citizen, including me, who has a law degree, would have recognized way back when, had it happened to me. So thank you, and I hope that your issues get resolved favorably. Thank you.
Thank you.
Okay, thank you, Councilor Duff and Councilor Hurley. And thank you very much for your presentation today. And we emphasize that we appreciate your coming forward and sharing your circumstances with us. And we will continue to work with our colleagues in the legislature and in the judiciary to address these issues. Thank you very much. Are there any other witnesses who wish to testify this morning? Okay, we do not see any, and we do not have any on the screen. That concludes the witness portion of our hearing this morning. We would now like to hear from Justice Wendlandt, and we invite you to present your testimony.
Thank you, Lieutenant Governor and councilors. Good morning. As you heard from Justice Buno, and as you remember, I was before the council just a few short years ago in May 2017 on the anniversary of Brown versus the Board of Education. So I won't repeat what I said then. Today, if you'll indulge me, I just wanted to focus briefly on 2 points. The first is I wanted to reintroduce myself, tell you a bit about my story, the stuff that is not on my CV, and why I recognize that it is an important tale to tell, a tale about identity. Second, I wanted to tell you why I applied to be an Associate Justice on the SJC. I wanted first, though, to thank my witnesses, my husband, my daughters, my son for watching, and thanks to Zoom, my mom, who can be able to watch from Chicago. Since my nomination, I've received many notes that have been really overwhelming. I, as you know, hail from Chicago, and I received many notes from colleagues I hadn't heard from since high school. I received notes from my colleagues at MIT who I hadn't heard from in a few years, and some of whom I'm really still very close to. And I got notes from the West Coast as well at Stanford. And then the buzz went international, and I heard from my cousins in Columbia. So I thank the governor and the lieutenant governor for nominating me, if only to reconnect with these people. The shower of congratulations has been overwhelming. So who am I and what is my identity? That existential question has transformed for me over the past several years on the bench. So let me tell you what my answer used to be. As a trial lawyer for 20 years at Ropes and Gray, the question prompted my so-called elevator pitch. I would say, I defend my clients' most valuable assets, their proprietary inventions, against pirates, against unfounded accusations of intellectual property theft, and I win. Today, my answer is different, not only because I traded advocacy in to don the judicial robe of the appeals court, but because several years ago, I learned something that shocked me. When I submitted my application for the appeals court, and I'd gone through the lengthy process of due diligence and met the governor and the lieutenant governor, I was asked if I had a story to tell. And as I reflected on that answer over dinner with some friends and colleagues, I asked them, well, do you think anyone might be interested in hearing about my Latinx roots? And their reactions surprised me. They said, I don't think of you that way. You don't look Latina. And this was enough of a constant refrain that I learned that even some of my closest friends, my partners and colleagues, had no idea about an aspect of who I am that is so fundamental to who I am. My core identity, and that is the following, that I am keenly aware that I am who I am because of a decision I had absolutely no part in making. My parents' decision to immigrate to the United States in the 1960s from Colombia, South America, to forge a better life for their family and to plant roots in this new country. And it is with immeasurable pride that I carry the weight of that decision. It permeates every aspect of who I am. So I am here before this honorable body saying I have been blessed by the gift of the American dream. My father grew up in real, abject, third world poverty, the son of a single mother. And somehow, in a story that I will never know the full details of, he was able to get a medical degree in Cartagena, Colombia. He married my mom, and together they traveled to the United States. sight unseen. They settled for a few years in New Orleans, where I was born, and the rest, as they say, is history, a story that you can garner from my CV. But I wanted to tell you this nugget about who I am, my identity, so that you will know. Yo soy americana de primera generación. I am a first-generation American. Yo soy una persona para quien el inglés es su segundo idioma. I am a person for whom English is my second language. Soy una mujer ingeniera. I am a woman engineer. Soy madre. I am a mother balancing the competing demands of work, children, and family. Fui socia en un bufete de abogados internacional. I was, for the last decade, a partner in a large international law firm. Y ahora soy juez, and now I am a judge. I say this in no sense to brag. Sería la primera en decirte que soy el producto de mucha suerte, ayuda y soporte de mis amigas, familia y mentores. Because I would be the first to tell you that I am the product of a lot of luck, a lot of help from mentors, parents, family, and friends. Far from bragging, I tell you this because it is my duty to all those who have helped me. Because it has become increasingly obvious to me that my story is relevant to others. I feel the privilege and the weight of the responsibility to upset any preconceived notions and expectations as to the kind of background, the identity of a person who sits on the other side of that judicial bench. Identity is important. Y yo soy Latina. And I owe it to my parents, my husband, my children, and to my brown, Black, and white mentors and heroes upon whose shoulders I humbly stand to say thank you to them and to speak my truth. The second important message I wanted to share with you today is that I do not want this job because I am Latina. I applied for this position because, like Martin Luther King Jr. said, the time is always right to do what is right. You have hired a great team at the SJC, legal giants who have shown themselves capable and dedicated to the cause of justice in the Commonwealth. But with the sudden and tragic death of Chief Justice Gantz, the new Chief Justice is going to need assistance. And I am confident that she has that in the existing justices, but I think I could also help. As someone who has experienced navigating clients through crises, setting a strategy and defining metrics that make sense and ensure progress toward a shared goal, I offer my experience. My willingness to roll up my sleeves and solve complex problems that seem insurmountable at first by breaking them down into manageable steps. We face, as you all know, a global pandemic and a call to end decades, no centuries, of racial injustice. And I don't pretend to have all the answers, but I offer a consistent, rational, and compassionate perspective to the chief. I'm also aware that as December 2020 draws near, the team that you have hired is losing Justice Blank's depth of civil litigation knowledge. And I think my experience of 2 decades of high-stakes, complex litigation might be what the court needs to attempt to fill that void. With all the innovation, technology, and economic boom that is crowding in on my old stomping grounds at MIT and throughout the Commonwealth, we need a jurisprudence that gives those companies the assurance that the complex nature of their disputes can be settled here by our more than capable jurists. Jurists willing and able to do the hard work required to dig into the knotty and multifaceted problems that those companies face. And I humbly offer my years of experience to the Commonwealth. And so I thank you. I thank the governor, the lieutenant governor, the SJC nominating committee and its chairman, the governor's legal counsel, the executive director of the JNC, and I thank you, counselors. I am humbled and honored by this nomination. I thank you for taking the time to consider whether my life experiences, my leadership skills, and my depth of knowledge provides a voice that deserves to be heard at the table of the Commonwealth's highest court. Thank you.
Thank you, Justice Wendlandt, for your statement of testimony, for sharing your story, and for the inspiration that it presents to all of us. I'm certain your mother, who's watching from afar, is very proud of you at this moment. And for your willingness to step forward, to offer your experience, to assist our highest court at this time and in its future is very appreciated, and we are grateful to have your name and nomination before our Governor's Council members. We would like to now turn to the portion of our hearing where our councilors will question our nominee, and we will begin with Councilor Devaney, who is your host councilor.
Nice to see you again.
Good to see you.
Thank you for all the time you afforded me at the diner. It was great to see you again. And as pursuant to our protocol, I am your district counselor, and I was so pleased to preside over your hearing for the appeals board. And I can't tell you how I regret I'm not allowed to preside today, but I'll always be a district counselor, you know that. First of all, I am first generation American. And I am just, I mean, that's the American dream, what your dad accomplished, really. My dad never got further than 12 years old in education. And I just envy you for knowing your language. And I don't know one word of Italian because of the discrimination and of the prejudice that they faced. And so they didn't teach us a word. My dad came to Watertown when he was a young man. There was no discrimination laws, and they wouldn't allow an Italian to work. He pretended he wasn't. He changed his name. He went to court, and that's how we all happened. And my mother came at a different time. She was younger as a child, and she experienced the same. So you are the American dream. And I'm so proud of you, really. So, everybody has different paths when they come to this country. So, one of the things that I'm concerned about, I want to ask you first, did you see Judge Budd's hearing?
I did watch.
Okay, you did. And I did tell you that I am very concerned about foreclosures. And I am really trying hard to educate myself, and I'm appalled what's happening in the court for these illegal foreclosures on people. And they are illegal. And I served on the Commission on Disability for 22 years. And I'm especially appalled how people with disabilities are treated. And so that's why I really think that the SJC has to be educated on this and has to have a committee. And I am going to recommend two people who have worked tirelessly. And that's Sarah McKee, who was a former federal prosecutor, general counsel for Interpol for the United States, for Governor Patrick's Register of Deeds Commissioner, and Grace, and she is a member of the Alliance Against Predatory Lending, and also Grace Ross, ROSS. And she is a coordinator for Mass Alliance Against Predatory Lending. And this is the only statewide organization that fights illegal home foreclosures through organization, through legislation, and litigation. So these are the two people that really have such compassion in working for these people. And so, so my focus with you is to learn about foreclosures. Now, that committee could be, you can frame it anywhere. I can't as a counselor do that, but to investigate the violations and report to the SJC, because it is happening and people are homeless. People are committing suicide. I mean, it is a dire need that we do something about what's happening in the court. Now, I will, for people who didn't hear some of those questions, I'm going to repeat some of the questions that I did ask Judge Budd. Now, and I mentioned this to you, so I'm hoping that you look into it. And I wanted you to tell me what you know about title theory.
I know that Massachusetts is a title theory state, meaning that once you get a mortgage, you retain the equitable title. I'm speaking as the homeowner. You retain your equitable title in your property, and the legal title is held by the note holder or in trust by the mortgagee.
Thank you for looking into that. I appreciate it. How about the UCC? What did you find out about that?
Well, I mean, we've adopted part of the UCC, so if that's the question, it's already been done.
And, well, what is the purpose of the UCC?
It's to have a uniform commercial code that companies can work throughout the nation and understand what the laws are in general from state to state, and that they provide a uniform basis for it.
Okay, so it oversees all contracts, consumer contracts, commercial contracts. Okay, now I'm going to go over some of the, no other word but outrageous, and it makes me cry, some of these cases that these are real people. And you know what? I'm getting letters from people from the last hearing, from Judge Budd, people who are not in my district. One man who was homeless, has no money, his house was taken away, and he sent me a letter, and it cost him $4.12, the stamp, to send it to me to make sure that I signed for it. These are people hurting, really hurting. And, it's even lawyers who have been affected. And we did hear from, from Attorney Brown, who talked about 10 years she's been going through this. So I can't document everyone that I'm hearing from, but I am going to go over, because he is filing a suit. God bless him, and he deserves it. And that was what we talked about, and he testified here last week. Mr. Salitro. Mr. Salitro was born blind. And now they're going to foreclose his house. They told him he didn't have to, a lot of false information. They told him he didn't have to pay the mortgage because because they were, going through this foreclosure. And so then they demanded the money. It was just awful. But the point is that he was threatened without any notice. The housing court judge threatened him in open court either to work something out with the bank that morning or else go to the jury trial that afternoon. Guess what? They don't have trial in the afternoon. Everything they said to him was a lie. And so, of course, he can't read. And they had him sign this document. A blind man sign it, not in Braille, not any kind of, accommodations. So what happened was, and he had worked for the Worcester Sheriff's Office, and he had to quit to take care of his both parents had Alzheimer's and one had cancer on top of it. And so, so they said that he falsely read it. I mean, of course, he couldn't have read it. So he signed away all his rights to his home, and the judge signed off of it. And he got a few $1,000s for the family home, which he grew up in. And he was rejected, his complaint, without docketing it. So now he's going forward. And, this is the organization that is helping him. And I'm going to say it right out now. This is Judge Diana Horan, documented. I have the name documented, okay? And she is the one that has been, and it breaks my heart, because I'll tell you something. As a governor's counselor, I don't have a crystal ball how a judge is going to conduct themselves if they're going to really show that compassion that I asked for, okay? So, so this is, he's dealing with that. So he's homeless. So that's one. I'm not going to get to all of that. So he's going forward. Now we had a young woman in her 20s and not a lawyer. And she did, they reported she did an excellent job in defending herself in a loss of a home. And she came dressed very professional. She had all her papers all in order. And people were impressed because she was better than any lawyer presenting it. And Judge Horan said to her, "What education do you have?" How rude, how egregious for her to ask. She had an associate degree. My father was 12 years old when, you know, he came to this country, and that was it. They put him to work, and that was what it was. But I felt he was intelligent, my father, okay? And she was too. And she did a super job. And no one should be belittled because they don't have some degree or they are not a lawyer or whatever. And I feel that here. I get it all the time. So I know. But she had her day in court. But you know what? When someone comes in to self-represent themselves, they're not allowed to bring any devices. They can't bring their cell phone or anything. But the lawyer can sit there and have all kinds of devices and everything else. And then one of them was, she punished one person because they didn't come to court and they were on an IV in the hospital. I mean, you can't make this stuff up. You can't make it up. But everything starts in the land court when these foreclosures. And that's why we need more money from the legislators, and it has to be especially focused to the land court because that's where it starts. Then there should be mentors to educate people on the SJC, the district court, all of the courts to know what is happening with these foreclosures. And when I see document after document with a judge that I voted for, I can't tell you how upsetting it is to me. These people are living in cars, they're homeless, they have children, their children aren't doing well in school. I mean, they're out of work. I mean, what this has done, and you know, like I said, it's a land court where, you know, where it starts. So anyway, so, you know, so the thing is, yes, we are a title theory state. The borrower conveys the actual ownership of the land to the lender. And this is security for repayment of the loan. But guess what? The judges in our court are not demanding to know who the mortgagee is. So we have these unknown entity from New York, and those are the people that deliberately are going after these vulnerable people and taking their homes. There's no justice. There is no justice. And I have to admit, I didn't know what was going on in the housing court and the land court. And I am, I'm not a rocket scientist, but I'm really learning. And I have such respect for these people who don't get paid and who are in this organization, and they're helping those people. They're telling them what their rights are because their rights have not been allowed by what's happening in the court. And this is going to be with you, the foreclosures, for years and years and years, especially with the pandemic. How many people are out of work? I have a son out of work. This is a very difficult time. And if you can't pay your mortgage, there's some unscrupulous mortgagee that is going to zoom in and take your house. So that's the thing that, you know, that I'm concerned at. And so these defendants representing themselves, they're petrified to go into court. And the defendant, and, you know, to say someone you don't have education and all of this is so unacceptable. And I want an investigation about her. I want to know what's happening in that court. All of these people, I could tell you a lot of other cases that she has dealt with. But anyway, the thing is that, you know, what do you think can be done about this? You're going to be on the SJC. What are you going to do about it?
Well, thank you for sharing those stories. I think
I'm sorry, I'm emotional. I'm Italian.
no need to apologize. I think it's important to tell these stories. I think it's important for the SJC to be aware that these situations are happening. I think it's also important to reserve judgment until we've investigated more, which is what I always do. You know, I roll up my sleeves and I look at the data and treat people compassionately. I think there's no excuse for not treating people well. As the child of two parents who spoke English as a second language and really broken English, I know what it is like when they would go to parent-teachers conferences on my behalf, and I was their translator, and teachers would say to them, you know, some comment about my behavior, not always great, and I would translate for them, and the teachers would get frustrated and speak louder to them as if they couldn't hear. Something was wrong with their hearing, and in fact, it was just a language barrier. So I understand the need to treat people respectfully.
Well, that's generational too, because I certainly could talk English, but when I used to play in the park, they never called me Marilyn. They just call me the G word and tell me to take right field or whatever. So I know discrimination. I know it well. So, and I'm glad that you pointed it out. You're not here because of your ethnicity. You earned it the old-fashioned way. And so that means a lot to me. And you know, and I know you well, and met at the diner, well, total 8 hours, the both times that we met, and got to know you very well. And I was very proud and watched you on the appeals court. And I know that Judge Green has such high esteem for you. And so I just, but I can't be more emphatic that the JNC has to look, the SJC has to learn. They have to have that committee. They have to have mentors to come in and explain to all the district courts what this means. I think the most, the thing that bothers me the most is to have a judge lie and scare a blind person. You know, that is unbelievable. Or put down someone, all of that. But in the long run, we have had some cases that are going to go forward that are affecting us, that they have voted really on the wrong side, you know, for, so I'll tell you one that's going to be at your door too. And that was the Bank of New York Mellon versus Alton King. Do you know about that decision?
I don't think so.
Okay, that's from the SJC. And this case was against a senior African-American man. And what this whole thing about these foreclosures, illegal, seem to be targeting single women, disabled, or people of color. There's no question in everything that I've looked at, okay? So this was a case against a senior African-American man with a disability where they blamed him for not being able to afford a mortgage that was given to him. It was a package of mortgages that was almost 150% of the actual property value because they provided him with an illegally, dramatically inflated appraisals. So what happens? He couldn't afford it. It wasn't his fault. It is called structural racism. They are supposed to be dealing with that. Instead, the Alton King explicitly held him responsible for the structural racist, never affordable mortgage. Okay, so I'm just learning a lot about this, and I'm not going to let it go. And I'm just asking you what you plan to do on the SJC. Will you support a committee? Will you have mentors to come in and educate the SJC, the district courts, all of the courts, because these people aren't aware. But the land court is where we especially need the money from the legislators. They need people that can counsel them, that can give them the support that they need. It's needed desperately. And hundreds of thousands of people have lost their home illegally. So that's, I'm putting all my eggs in one basket here. This is all about foreclosures. And I think to myself, and it affects widows too. And I'm thinking, God, what would I do? That could happen to me because you don't know, you believe, you trust the judge, you trust the system. But the judge doesn't even ask who the mortgagee is. Do you think that's acceptable? No. So
No, I mean, in fact, the law requires that only the mortgagee has standing.
Right.
As,
Well,
as the witness previously said.
I'm telling you, I mean, I couldn't be more concerned about this. And I just think that it's, and then they have I looked into a Service Members Civil Relief Act, which protects the borrower, that one, and temporarily from foreclosure. And yet, land court dismisses these cases. So it just seems like what does protect the person to keep their home, So, okay, I've thrown a lot at you. I'm sorry to get so emotional about it, but I have gone through these cases and I've cried. It's sad. So I'm hoping that Mr. Salitro, the blind gentleman, can find justice after all this time. Another woman, an attorney, Brown, and she has been fighting 10 years. Enough is enough. They need help. So we need that committee. We've got to investigate and remember that judge, Diana Horan. And she's in all of these documents, and Salitro and all of them, that they have complaints going forward. So I don't find any joy in saying that because I have voted for wonderful judges. Justice Green, Justice Gantz 3 times, Justice Island 3 times, and you know what? We have to change that 70, and I'm going to keep saying it. Those people out there who have the authority have to do it. It makes no sense in this pandemic. We're calling on retired judges, 74, 75, yet they were forced to retire when they were 70. No one can explain that one to me. It doesn't make sense. So I'm going to get off my, I've gone on and I've talked too much and you didn't talk enough. And I just want to ask you, what do you think the biggest learning curve will be for you to go from the appeals board to the SJC?
I think probably the biggest learning curve will be really how the SJC functions. I'm very familiar with how the Massachusetts Appeals Court functions. And, I think the first sitting that if I'm confirmed would happen in early December and just getting up to speed on those cases. And then there is, as you're commenting now, the superintendent power. And that is something that the appeals court does not have at the SJC, will have to look into things like these foreclosure issues that you're raising.
Well, one of the things I was impressed by you, about your, experience and qualifications to be an engineer. I mean, that is an amazing thing to, to follow that path to be an engineer. Because I'm sure when you went to school, there wasn't very many women engineers. So I think you have brought to the appeals court, just like Justice Green was the first from land court. I think that's what you need, that diversity of people who bring their talents to the court. So I'm looking forward to you, to do great things up there. And, again, it was such a pleasure, to spend that time with you and to be a district counselor. I am absolutely over the moon. So I'm very proud of you. And so thank you for letting me vent.
Thank you, Counselor.
Thank you.
Thank you, Counselor. We're going to take a recess so that we can move to the Assembly for the Governor's Council. And after the break, we will resume at 1 o'clock and Counselor Ferreira will begin the questioning at that time.
What time is it?
Okay, do you want to do the Assembly now? Okay, Chris, yeah.
Christopher, Assembly.
Okay. It is a little after 12. Yes, yeah. I call our Assembly to order. Okay, and I'd like to recognize Councilor Hurley for our prayer and pledge today.
Thank you, Lieutenant Governor. In light of what's going on with the pandemic and in light of everything that has gone on with the election, I'm going to say a prayer for healing power. Father, please forgive us for wanting to give up and turn away from you. We are so tired and so hurt. Please give us the strength to go on. Today, we choose your healing power to work in our lives. We will guard our hearts against bitterness and anger. We will not retreat. We choose to believe that the pain of today is the foundation of tomorrow's victory. And to all of us who have friends and loved ones who have been lost, a special prayer for each of you to deal with this issue and to have peace in the long run. Amen.
Amen.
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Thank you, Councilor Hurley, for leading us in that beautiful prayer today. I'd now like to recognize Councilor Kennedy for a motion to record advice and consent for the financial warrant.
So moved, Governor.
Second.
There's a motion and a second. All in favor, say aye.
Aye.
I recognize Councilor Duff for a motion to record advice and consent for the pending list of notaries public and justices of the peace.
So move, Governor.
Second.
There's a motion and a second. All in favor, say aye.
Aye.
I recognize Councilor Jubenville for a motion to record advice and consent for the appointment of Daniel J. O'Shea to the position of Associate Justice of the Superior Court.
So moved, Your Honor.
Second.
There's a motion and a second. Councilor Jubenville.
Wonderful appointment, wonderful man, and a wonderful judge. He's got all the qualities you need, both as a man and as a judge. Thank you very much for nominating him.
We may begin the roll call.
Councilor Kennedy,
Yes.
Councilor Hurley,
Yes.
Councilor Ferreira,
Yes.
Councilor Jubenville,
Yes.
Councilor Devaney,
Yes.
Councilor Ianella,
Yes.
Councilor Duff,
Yes.
7-0, Governor.
Thank you. I recognize Councilor Devaney for a motion to record advice and consent for the appointment of Associate Justice Kimberly S. Budd to the position of Chief Justice of the Supreme Judicial Court.
I am so honored to be able to make the motion
Second.
to appoint Judge Budd as Chief Justice of the highest court in Massachusetts. I have followed her judicial path as her district counselor, presiding over her hearing 11 years ago. So in those 11 years ago, I have seen her. She's never let me down. She has all the attributes. She is compassionate. She has empathy. She has all the qualifications, and she has the demeanor and temperament that we need in that position. And I wish her all good luck and happiness in this position. And I make that motion.
There is a motion
Second.
and there's a second. Councilor Duff.
Thank you, and I ask you to indulge me for a minute. I just received a letter I would like to read, and will submit it into the record. Dear Councilor Duff, I wanted to let you know how pleased I am to hear of the governor's nomination of Kim Budd to serve as Chief Justice of the Supreme Court of our Commonwealth. I encourage you and the other members of the council to support this nomination. As you know, I had the pleasure of meeting Justice Budd when she and Justice David Lowy spoke with the students at Peabody Veterans Memorial High School. The presentation was absolutely wonderful, and I still hear rave reviews from students who attended that event. Yes, there is a lot of Peabody pride involved here in this letter, but on a professional level, I would like to share with you and your colleagues on the Governor's Council my reasons for sending this letter. I will be speaking in my capacity as a very experienced school committee member and as an attorney. One of the most impactful results of Kim Budd speaking with our PVMHS students was that she showed all of our students that as a minority, she had experienced many things that our minority students had also experienced and understood those experiences. She handled the discussion with compassion and strength. She wasn't just an alumna of PVMHS. She was a woman who had achieved greatly, but due to her life experiences, she intrinsically understood their lives too. That is a quality that is priceless for anyone. But for an attorney and a judge, it is paramount, especially in this time in history. So many young women in that room were impressed and inspired to follow their dreams and succeed. And many still speak to me of that day and their plans for their futures. Kim Budd affected our students in many, many positive ways at that event. I continue to appreciate what you did to make that day possible because on many levels, what seemed to be a simple visit actually turned into a life-changing event for many of our students. The qualities Kim Budd exhibited that day are the qualities all of you and the governor have recognized. And I thank you for supporting this nomination in the selection of Kim Budd as Chief Justice. Sincerely, Beverly Ann Griffin Dunn, Attorney, Peabody School Committee.
Lieutenant Governor, we're in the middle of a motion. I made the motion. Is there a second?
There is a motion and a second. Councilor Duff, thank you for sharing the letter of support from the Peabody School Committee. That clearly was a moment not only special to Justice Budd, but also to the Peabody community. That was terrific. Any other counselors?
Lieutenant Governor,
Yes, Councilor Hurley.
I just want to say how proud I am that Kim Budd's family has been generational here in Springfield. And each generation has shown how powerful work ethic and a family that has the right attitude can be. Captain Joe Budd was the first Black superior officer in Springfield. Wayne Budd had a career that was stellar, and now Kimberly has surpassed him. And I'm just very proud as a citizen of Springfield to say that.
Thank you, Councilor Hurley. We share your pride. Anyone else wish to be heard? Okay, we have a motion and a second. We may begin the roll call.
Councilor Hurley?
Yes.
Councilor Ferrera?
Yes.
Councilor Jubenville?
Yes.
Councilor Davini?
Yes.
Councilor Ianella?
Yes.
Councilor Duff?
Yes.
Councilor Kennedy?
Yes.
7-0, Governor.
That's terrific. Thank you. Today, we have a new nomination, Judge Serge Georges, Jr. of the Boston Municipal Court to the role of Associate Justice of the Supreme Judicial Court. Counselor Jubenville, this falls within your district.
Maybe we put that on for December 2nd? Is that a Wednesday?
Yes, it is.
Okay, December 2nd at 9 o'clock.
December 2nd at 9 a.m., the hearing of Judge Georges.
Thank you.
Thank you. That concludes our business for the assembly, and we stand in break until 1 p.m. for the, yes.
Where it's almost 12:30. It's going to be pretty hard to get. Can we make it 1:15, 1:10?
1:15?
Yeah, it's
1:15 is good.
We will,
Thank you.
that concludes our business of this assembly, and we stand in break until 1:15 for the hearing of Justice Wendlandt.
We leave our connection on though, correct?
Councilor Ferrer, is that you?
Yes, sir. I'm on.
All right, excellent. I'm just going to name you in our meeting. And I believe we're starting with you when we return.
Yeah. Do you know how long you're gonna start?
Should just be a few minutes. And I just want to let you know that we are live currently as well.
All right. Thank you. I will stand by and I'll be ready. I won't be on audio. I'll get some problems with my Wi-Fi, so I'll just be on.
Just be on audio?
Speaking. Yeah. Yeah. No video. I'm sorry. Yeah.
Okay, excellent.
All right.
Well,
thank you. All right.
bye.
Hello?
Hey, Mary, it's Joe. You're live now, just so you know. I'm going to start in a couple of minutes.
We're live?
Yeah.
Okay. Thank you.
Okay, I call our hearing back into session. And I can recognize Councilor Joe Ferreira. If you are present, Joe.
Thank you, Governor. I am present.
Okay.
By voice only. I have some issues with the Wi-Fi right now, but I'm ready to go.
Okay. Justice Wendlandt is ready for your questions.
Thanks, Justice. So let me start by saying thank you so much. We met in person a few years ago when you were first nominated, and I voted for you. Then we met in person last week, and you answered all of my questions in person last week. You have it all going, as they say. You are, one of the most remarkable nominees I've ever seen in my short 6 years here. And I know you were talking about, people were talking to you about predatory lending. Have you actually written any decisions or dealt with any predatory practices on the appeals court to date?
I have. I had a case called Citadel where the borrower entered into a series of mortgages that just kept escalating. And in that case, we ultimately decided that the foreclosure needed to be voided because the mortgagee had failed to garner the highest possible price. The mortgagee ended up selling the property to itself. And we realized that it was necessary to void the foreclosure and send the case back to the trial court.
Great. Well, I certainly appreciate that explanation. It's near and dear to all of our hearts. Obviously, we don't want people being foreclosed on unnecessarily, and we want everybody to have a fair shot. Also, I've had some experience with predatory lending. Those people you see on TV will give you cash today instantly. And I was involved with some litigation with a Philadelphia lawyer, and it's been nationwide where they're putting mom and pop businesses out of business. People that have been in business for 100 years, 150 years, they go online, they take these loans, and when you do the math, when the people take their fees and you're paying, and then you can't pay anymore because they're taking cash electronically out of your register every single day. When you can't pay anymore, they have one of their other friends call you, and you take the second loan, and then you take the third loan, and some people take 10, 15 loans, and at the end of the day, people are paying between 100 and 200%, which is usurious, as you know. So I'm glad that you have applied. I think your breadth of knowledge is extensive. I think you're going to make a great judge. I want to thank you for your service. You're one of those people by far who I know took a massive pay cut. So this is true public service for you. And I am so happy, and I will be voting for you next week.
Thank you, Counselor.
Thank you.
Thank you, Counselor. Thank you, Counselor Ferreira. I'd now like to recognize Counselor Jubenville.
Thank you, Your Honor. And Your Honor also. That's the official name of the Lieutenant Governor of the Constitution, to refer to the Lieutenant Governor as Your Honor.
Seems fitting to me. Whenever somebody says it to me, I look back to see who they're talking to.
Yeah. So where do I want to start with you? Oh. I'm not going to read the whole letter, but did you read the letter that Judge Gantz and all the Superior Court judges signed about the racism issue within our courts?
I sure did.
Yeah. That was quite a letter.
I agree.
So what are we going to do about it?
Well, I think you need to take that Harvard study, which clearly shows that there is racism, systematic racism in our criminal justice system, and affect change. I think one of the things that the SJC is currently doing is changing the way people can prove racism. Speaking of the Commonwealth versus Long decision, and making it possible without statistics to make a reasonable case for pretextual stops.
Well, I mean, I like the letters and I hear the talk, but I don't really see a lot of action. Just let me refer to the Harvard study. A judge asked Harvard to find out why so many black people were in prison. That was Judge Gantz. They could only find one answer. You know what the answer was? Systematic racism.
Right.
That's all. That study indicated that the commission found 655 people, of 655 people of every 100,000 black people in Massachusetts are in prison. That is an enormous amount of people in prison for 100,000 in the class of people.
I agree.
Just about every country, major country on earth, incarcerates about 250 to 270 people per 100,000. So the state of Massachusetts is 3 times what other countries are doing. Our country is somewhere in that area, or the whole country. And I'm sure you've heard, we incarcerate more people in the United States than in any country that ever existed on earth for population. More than the Russians, Chinese, for population, we have more people in cages than any country that ever existed on earth. That's a terrible statistic. So it says, meanwhile, the state locks up about 82 of its white citizens for every 10,000, 100,000. So 655 for black people, 82 for white people. So, again, I asked the chief if there was any education being given to all of our judges about racism, how to recognize racism, how not to let it affect them. And she said, no. How will we ever get anywhere unless we have every judge go to these seminars about racism? How are we ever going to do that?
I think it is important to train judges on racism. I think the Harvard study provides some data that perhaps people felt was needed in order to convince them that there is racism. My own view is it was not surprising to see the data support my own anecdotal views of the criminal justice system, not just in Massachusetts, but throughout our country. And I think the dialogue of racial innocence is wrong. People think that racism is something that happens in the South, and it is, but it also happens right here in our own Commonwealth, and it needs to stop. And I think we go beyond implicit bias training, which all the judges, as I understand it, have gone through, to allow open conversations about race and how that is affecting our justice system, because it undermines the idea of fair treatment. And when you have statistics like the ones that you're reading.
You know, the last 3 or 4 months that we've been coming here, we've been asking judges, all the counselors, do you think there's racism in our court system? I think every one of them said yes. And I think Councilor Ionella asked one candidate, have you ever seen it? And I think the person said yes. I said, well, who did it? Well, I don't remember who did it. So everybody talks the good game, but nobody ever says, hey, Judge Smith, you know, I'm going to report you for having racist tendencies. But how do we stop it without taking some action? Letters are nice. In fact, Judge Gantz, in the letter that he wrote, that's signed by all the judges, it says, in effect, talk is great, It's wonderful, but it's not going to get the job done. So we can talk here at the council about it too. We can say to judges, let's start talking about it, but it's not going to get it done. So you're going to the Supreme Judicial Court. So what are you going to do about it?
So what I plan to do about it is not necessarily out people who I feel have said something that could be perceived as racism, but to identify that. It's what I've done my whole career, to allow people to have a space where they can feel free to make comments, and then to have others comment on those comments and to point out to people, because I don't think people think of themselves as racist, most people that I know. And it's only when you point out how they're perceiving the world and what that does to their judgment that they have an eye-opening experience.
Okay, so big court system out there in the Commonwealth, right? There's what, 300, 350 district court judges? How would you ever know who's going to keep track of all those judges to say or not say that they seem to have some implicit bias against Black people or brown people?
Well,
Who's going to do that?
I don't think that you canvass each one of the judges. I think that you bring them in for trainings and show them what they're doing is racist. So, for example, this is not racism, but so, for example, I attended a domestic violence training when I first joined the bench, and it was perhaps the most eye-opening, truly changing experiences that I have ever had. It's a training run at that time by Judge Hanlon and Judge Hinkle, and it put you in the position of a domestic violence victim. And you had to make choices based on your limited resources. And it showed, at least me, why it is that some people who are subject to domestic violence don't leave their abuser. And it was an eye-opening experience. And I think something similar can be done with racism, and help people understand what that means.
Okay, so this study was commissioned in 2018, right? I believe it was.
Okay.
For 2 years to do it. Half of the court system people refused to give them documents. They had to fight like heck to get any kind of information from our own court system. And they didn't get all of it. What does that say about the court system? They're sending out people from Harvard to do law school to do a study on racism, commissioned by all accounts by Chief Judge Gantz, and they're not even be given the documents they need to address it. Isn't that racism in itself in parts of our court system? Why would you not give that?
So as I understood the report, as I read the data collection process, the courts did provide the documents. The problem is that the way the courts, the various trial courts gather the information is inconsistent from court to court, inconsistent between court and probation. And so it was hard to follow any particular defendant. I think where the researchers failed to get data was in connection with asking about arrest records and who was arrested. I think that information was unavailable to them. And also it was unavailable in terms of the charging decision by the DA's offices. That information was not available. And as I understood the conclusions of the report, the single biggest factor in the disparities that we're seeing were the charging decisions, the mandatory minimum sentences, of the initial charge, resulting in sentencing disparities at the end of the game. And so you're right, the data was incomplete, and hopefully we can do something about that.
Well, the DA's offices and the people that have the records on arrests are paid by the taxpayers of the Commonwealth. They're agencies of our government, right?
Correct.
So I think it proves the point that if you're not going to give those statistics for some reason, and I don't know why you wouldn't, that it shows some of the problems getting at this issue in the first place.
Yeah, no, I agree with you. I think those are executive branch and legislative branch issues. I think that given that you've asked every nominee, is there racism in the judicial system? And the answer is uniformly yes. And this study shows that yes, there is. I think while collecting more data is interesting, I think the time has come to roll up our sleeves and solve the problem.
So we can expect that day one after you're sworn in, you will say to the chief judge, the others, how about we mandate that every judge go to training on this as a start? Because she said we don't have that now.
Right. I would definitely support that.
Well, supporting it's good, but you got to be bolder than that, I think. Government moves slowly. Government doesn't want to change. We don't want to change as people. Governments don't want to change at all. So Judge Gantz did something about it. He took a bold step in getting this study being done. But we need somebody now to finish it. So can we count on you to be the one that finishes it?
You can count on me to continue to carry the baton.
Okay.
I think it's a big task to say I'm going to end racism in the criminal justice system.
I don't think you're gonna.
Yeah.
When you look at racism from the inception of our country, you know, the Civil War, the Emancipation Proclamation, it went up to 1955, Brown versus Ward. It still didn't get it till 65 when Johnson did the Civil Rights Act. 1965. A whole 100 years plus went on. And it's still not there. So, got to carry the baton high and push.
That I will do.
We will be checking on you. Our spies up there will tell us what you're doing. Okay? Because it is a problem. I'll give you an example of what I now consider to be racism, and I didn't a few years ago. And it's in looking at a defendant's record. And it is why I think contributes to the fact of this figure of 655 per 100,000 Black people. Because most minorities, not just Black, live in areas of a city that get more attention by the police. And they get arrested more. They get charged with crimes more because of that interaction. Much greater than in towns like Wellesley or Weston or even my town of Milton. So the young kids in those areas end up with records much greater than the rate of white kids that are in some of these other towns. So when they go before a judge, they've got a record. The judge sentences, he sees that record. So he sentences them more harshly because of that record. And to me, that is a racism, because those kids didn't have the same chance the white kids did. And the white kid doesn't have that on his record. So I've come to the conclusion we shouldn't look at somebody's record. I know it's way out. I've looked at them all my life, 42 years a lawyer, being a policeman. I look at the records all the time. First thing you do in courts, it's like a program thing. But then I say, why do we do that? Why can't a judge sentence somebody based on the crime he committed? And not because he did other things prior in his life that he's already paid society for. We say that, always paid society. Well, the only place he doesn't get credit for it is in the court system. They use it against him all the time, or her. So I don't think that's fair, and I think it affects disproportionately minorities, maybe contributing to these figures that we see in this study. I'll just read these off. There are 18 examples of racism in the criminal legal justice system. I won't read each I'll just read each category. 1 is police stops. 2 is police searches. Police use of force during an arrest. Juvenile arrests. Arrests in the transgender community. Arrests for drugs. Police arrests for marijuana. Pretrial release. The National Academy of Sciences found that blacks are more likely than whites to be incarcerated while awaiting trial. Prosecution charges. Studies show that black people are charged with more serious crimes, a higher level of crimes. Prison versus community service. Black people seem to get incarcerated more instead of being put on community service conditions. Length of incarceration. Minorities spend more time in jail for the same crime than a white person spends the time in jail. State and federal drug convictions. Much more affects the minority community arrests for drugs than non-minority communities. So they get incarcerated more for drugs. Federal court sentencing. You know anything about the federal court sentencing guidelines?
A bit, yes.
What do you know about them?
Well, I'll tell you what my experience has been with them, which is that the judges that I've spoken to that feel confined to issue a particular sentence based on what the guidelines say, often feel that that's not the appropriate sentence for the individual, given mitigating circumstances like what you're talking about, where somebody happened to grow up, and often aggravating circumstances as well. So at least when I was looking at them, the people that were required to impose them felt that they were constrained in a way that they felt was unfair.
Yes. When they first came into vogue, I believe it was in the late 70s, and they were mandatory in the federal court. And they were draconian, to say the least. I know a person who got sentenced, had no record, started selling marijuana in college, got up to a higher level, got sentenced to 20 years in federal prison for selling marijuana. And he did 85% of that 20 years. In fact, they were so bad that Judge Harrington in the federal court refused to sentence anybody in a criminal case based on those guidelines. In fact, he refused to take criminal cases and publicly made statements about that. They were so unfair to the citizens of this United States. So then they changed them and made them advisory only. But there's still a one-size-fits-all type of a situation. But to me, even worse than that is we now have them here in our court. It didn't work in the federal court, even as advisory, but we have them now in our court. In fact, the last couple of cases I had in the Superior Court, right away the guidelines come out. Judge, the guidelines this. Of course, if it's the guidelines are good for the defense lawyer, the guidelines for me. But I said to the judge, I would object to you using those. The legislature has not passed any law making those appropriate for punishing citizens of this Commonwealth. He said, well, they're only advisory. And I said, okay, my other objection is what data was used by whoever these people were I'm sure there's a list somewhere. I don't know if anybody's ever seen the list or heard of who sat on this austere body to decide how citizens are going to be punished. So that was all done in the dark. Yet, in every court, in every superior court just about in this Commonwealth, they're being brought up. You know, guideline says 3.5 years, and, you know, that's what I'll do. So I think the Supreme Judicial Court should take a stand on that. If I walked into a court tomorrow and said, Judge, I have my juvenile guidelines, I did them up last night, he'd think I was crazy. But that judge using those guidelines has never seen one bit of data to suggest that somebody that's 25 years old and commits larceny over $1,200 should get 2 years in jail. Nothing. He has seen nothing to suggest that. I think they're illegal. I think they're draconian. And I think the SJC should talk about it and change it. They serve no purpose other than to incarcerate citizens in jail longer than they would evidently get by not having them. And where does it fall? On the 655 minority people in jail for every 100,000. That's a form of racism, I think. Incarceration of women. Black women are like 3 to 4 times more are incarcerated 3 to 4 times more than white women. How does that even happen? How can that happen? And I go back to the one answer: systemic racism. Sentencing to life without parole. Hiring people with criminal records. It's a tough thing for somebody with a criminal record to get hired. When they don't get hired, of course, they can't get a job. They still got to live. They got to eat. If I don't have a job, I don't have any money, I'm going to steal to eat. If I got a wife and kids and I don't have any money, I'm going to steal to give it to them. It's the only thing I got. You're familiar with the Cotto case, Commonwealth versus Cotto, Judge Carey's decision on the drug court out in Amherst?
Yes, I am.
I'm not going to read it again. I read it last week when I was here. The terrible things that the attorney generals assigned to that case did. Hiding evidence from the judge, lying to the judge in open court, sending letters to the judge that the letters were lies. As a result, 70 or 80 people stayed in jail for about 15, 16 more months than they would have had they not lied. You're going to be in the SJC. One of your jobs is to deal with attorneys that are accused of misconduct in our court system and misconduct in the way they operate in their law practice. What do you do with one of these, somebody who does that? What do you think should happen to a prosecutor that hides evidence and somebody goes to jail because of that?
Well, I cannot comment on an open case.
There isn't any open case that I know of. This thing still open?
Not that particular case, but there may be an open case regarding to the discipline for those lawyers. I'm not sure.
Well, I hope they get around to it because this thing here was written when? This was written in 2016?
16, yeah.
4 years? They haven't been reprimanded yet?
Point of information,
Punished?
Bud said that it was still going on.
I don't know the answer to that question.
I don't know
my
either.
radar went up when you said, what do we do with these attorneys?
Yeah, okay,
Because it
but
seems
I
like
don't know
there
either.
should be, yeah.
And I think some of them, a couple of them, or one of them is still working for the government. All those people went to jail for that extra time because they lied. I don't think there's any, they don't pay a price for doing that. As a result, there's no incentive not to do it sometimes. Not all, most prosecutors are wonderful. But the few that aren't, they don't really get punished in our system. Now and then there's some punishment. It's rare. Defense lawyers get punished much more than prosecutors get punished. But the prosecutor is a different role. They have all the eggs, all the prosecutorial eggs. We don't. They give them to us. They're supposed to. So when they hide it, sometimes we don't even know they're hiding it. We don't know about it. And then 20, 25 years later, we see people getting released from prison that served time for a crime they didn't commit. Just generally on that issue, we see it all the time now with DNA. But at one point, some prosecutor stood in the courtroom and said, that man committed murder. He should not go to jail, but he should be punished. He committed murder. He's the one. 20 years later, he's not the one. He was never the one. How did that happen? How do we stop it from happening?
So in those particular cases, I don't know that the prosecutor lied, which is in sharp contrast to what you're referring to in Judge Carey's decision. I think
Well, there's a lot of ways to lie without saying you're lying. If the prosecutor doesn't turn over something to me,
that's a Brady violation.
It is. But to me, it's a lie because I'm led to believe under the rules that I'm supposed to get all this stuff. And when I don't get it and don't hear about it for the trial, then in effect, prosecutor lied to the court saying all discovery has been turned over and lied to me saying, Bob, I gave you all the discovery. So, but they have immunity to a certain extent. Police have immunity. Assistant DAs have immunity. So they don't seem to, some of them, just a few, but some, they seem to take the chance of doing it. If they get caught, they may lose a job. But somebody sits in a jail cell because of it. I don't know the answer how we stop people from doing that. I think if they were punished greatly, that would stop. If I knew as a prosecutor I did that, somebody went to jail for 10 years, and the penalty is, if I did it and they can prove I did it, I do 10 years in jail for what that person did. You think I'd take a chance of ever doing that again? I don't think so. Just a couple more things for you. So you know about the Massachusetts Constitution?
I've heard of it.
Yeah. And you consider that to be the supreme law of the land?
Of the Commonwealth, sure. Yeah.
Way up there, it's at the top, right? Yeah. So it was brought up earlier, and I just sort of make this point about it. I've said it before at council hearings. Well, the Constitution says that judges shouldn't sit after the age of 70. No question, right?
Right.
The Constitution says that somebody that becomes a judge can only become a judge by the governor nominating somebody and the governor's council confirming that nomination.
Right.
Okay. So how does somebody get to be a recall judge? At over the age of 7?
I'd have to brush up on that opinion of the justice's opinion of 1972, I think.
Well, when you do.
But go ahead.
I suggest you like pretzels? Get one of those big pretzels while you read it, because it's like reading a pretzel. What it says in effect is, and I haven't read it in a while, because there was a ballot question that the people of Massachusetts voted on. And that changed the Constitution. But the decision says that because that ballot question didn't say we couldn't have recall judges, then we can have it. Well, who would have ever thought to do the ballot question and say, well, we better put in here that you can't do recall either, because those people around the court system, they may have this little trick about getting recall people in. To me, it's like circumventing what the people wanted. And of course, even if there were recall, they should still have to come nominated by the governor and come to the governor's council, because that's what the Constitution says. The only way you can be a judge. It doesn't say you go to the Supreme Court and raise your hand and take an oath again. So you got to come here. So maybe you'll look into that case.
Yeah, I'll roll up my sleeves and reread that one.
Yeah, I'd like that. Get the pretzel too, because it's pretty slick wording there they used on that. What do you think of minimum mandatory sentences, general? You think they're good or bad for the court system?
I think they're, in general, not a great thing for the court system. As you said, it sort of interferes with being able to have individualized sentences, which take into consideration mitigating circumstances, aggravating circumstances, the crime at issue, maybe the criminal history. And it puts the discretion that the judge might otherwise have in the hands of whoever's charging the defendant, the prosecutor. And that Harvard study that you referenced says that as a result, minimum mandatories are more harshly applied as against to people of color.
Right.
So those are my observations.
So, okay, so there was a judge in Worcester, Superior Court judge, who was faced with a dilemma. She had a person in front of her that was under a minimum mandatory, a crime carried with it a 10-year minimum mandatory. She said, that's not fair to do to this person. It is not fair. So she sentenced him to 2.5 years in the House of Correction. Of course, the prosecutor appealed and went up and, but she did it to make a point. So here's my question to you. If that's the case, if that's the circumstance, that you say to yourself on the SJC, that sentence, I know it's the law, and I know it's 10 years, but that isn't fair to the citizen of this Commonwealth that's before me. I know that. There's no question in my mind. I say you can say, I'm not going to impose it because it's cruel and abusive punishment. It's beyond what is fair. It's cruel. And declare it illegal. Why couldn't you do that on the SJC? I mean, you and the whole court.
Well, so sentencing is a legislative function, setting the minimum mandatories.
Yeah.
If somebody could raise an argument that as a result, the minimum mandatory was unconstitutional, the supreme law of the land, then I could do exactly what you're suggesting. But I'd have to look at the arguments. I can't say Dalila Wendlandt believes this is unfair. That is not what I think my job is. But if somebody could marshal an argument consistent with prior jurisprudence, that this particular minimum mandatory, as applied to this particular individual defendant, results in cruel and unusual punishment, then I could, and I would.
We'll have to, I think Councilor Kennedy will look around for a case that's going to be able to get up to you. The last time you were here, did I ask you or somebody ask you about death penalty?
Yes, you did.
Same-sex marriage
Yes,
and women's right to choose?
I believe so.
I'm going to assume that you would answer the same exact way if I asked you those questions today.
That is correct.
Oh, here's something. Did you ever hear of people being on probation?
Yes,
Okay, and they pay a probation fee,
yes.
$65 for supervised probation. So if the probation officer doesn't do any supervising, you think they should get their money back?
No.
Why?
Well,
They're paying $65 for supervised probation.
I think what needs to be done is that perhaps more resources need to be allocated to probation so that each probation officer has less people under his or her charge, and so that they can do supervising. But I don't think that there's an individual private right of action to get your $65 back. I'm not aware of that in any statute, or certainly not under the Constitution.
No, but I've had it in court where I asked the probation officer what supervision he gave to the person that's paid the fees. And he said, none. I said, none. Did you call him once a month? No, I didn't do anything.
Right, and I think you're identifying a failure in the system, but it doesn't
But
give
why
the
should we take it out on
probationer.
the person having to pay? Why don't we give him his money back and then fix the problem so it doesn't happen again?
That is a persuasive argument. I don't see a private right of action for that, though.
My other thing is, do you ever do any appeals on operating under the influence?
I think I
cases?
have. Yes, sure.
Okay, do you ever hear this thing, field sobriety tests?
Yes.
So what do you think of those?
I don't know what you mean. Be more
Well,
specific.
I'd say it in the sense that I don't know why they're even allowed into evidence, because they're to establish that somebody is not able to drive a car safely. But everybody on the stand that's there as a police officer that introduces the field sobriety test, I ask, can you tell me any books or publications that makes the correlation between holding your foot off the ground for 20 seconds shows some sort of a correlation to driving a car safely? No. Can you give me any studies? Name them any studies that have shown that? No. There's nothing ever. So why would they be allowed in to evidence if there's no basis for them? Nothing to show that there is a relationship between that.
Yeah, I mean, I'd have to look into that. I have
Yeah,
no
I
idea
want you
what the data is. I'm a really data-driven scientific person. So if there is no social science behind the 9-step walk and turn, it would be interesting to know.
And the other stuff they do. The other thing is psychiatrists testifying in courts.
Yes.
Yeah, you know about the SDP hearings they have.
Yes.
Well, they go on all the time in the Commonwealth, and invariably there are 3 psychiatrists for the government and 3 psychiatrists for the defendant. And they all testify, the 3 saying that he's danger, the 3 saying that he isn't. And a lot of them make a lot of money testifying for defendants all over and getting paid by the Commonwealth. How is it that psychiatric evidence is even allowed into a court?
In general, I mean, in that specific instance, there's a statute.
No, I know why they're there.
Yeah.
But how is it that 3 people can say one thing and 3 people can say the other in every single case that's probably done in the Commonwealth with SDPs?
That happens all the time with experts. And the question is only which experts are more credible.
Yeah, but most experts, like doctors, are testifying about an injury. or a condition. And they say, yeah, Jubenville broke his arm here and it healed this way or whatever. Psychiatrists just say, in my opinion, this has happened. There's never any data to show that it really is or isn't, other than that guy's opinion. I don't get it with the psychs. There's nothing to say. You're wrong on this. Where do I look on this? You just say whatever you want to say about the person.
So I guess I would say this. I would question your premise that they're just giving their opinion. I mean, it is based on their analysis, the medical history, their interviews of the individual person. But I will agree with you as far as the following. When you have a medical injury, they're talking about what happened in the past and why that happened. And here we're trying to predict the future. And that is always more difficult, more dangerous proposition. And so the rules are slightly different. You know, medical injury, preponderance of the evidence. For SDP, you have to show clear and convincing evidence of such and such. It's not surprising to me that you would have experts disagreeing on something that is future looking.
I guess. The other thing is dangerousness hearings. You know, somebody's charged with a crime and the government moves for dangerousness hearing. The person can be held up to 3 days and they have to have a hearing. And if the judge finds they're a danger and says there's no conditions that I can release them, they're held in custody. In the district court, it's 120 days. In the superior court, it's 180. And I think it's a very unfair law for this reason. It's overused, much overused in this Commonwealth. And number two, I know people that have been sitting in jail on a 6-month Superior Court dangerousness hearing. I know this one person has been sitting there for 18 months because they're under the Rule 36 issues where trials are stayed. They apply to this statute. So the COVID, they haven't been having trials because of COVID. So the person sitting there doesn't get credit for that time. They've been sitting there all this time. If the lawyer files a motion for a motion to suppress, that time's excluded. And I think it's a terrible statute in the sense that it was designed, I think, to kind of put people in to cool the situation off for a while and to hold them for a while, like 6 months, and put them on some sort of bail conditions. But this is just a form of unjustified incarceration, in my view. That you can sit there for a year and a half, and every little thing comes up. Judge says, oh, I got to continue your case, judicial management. Person, it still sits in the jail. So I point that out to you because you may have cases be coming for you on that. I think it's terrible, terrible law. Do you think all police interrogations should be videoed?
Yes.
That was easy. Yeah, I do too. I don't know why we don't.
I mean, I guess if the person being videoed didn't want to be for some reason, maybe that would be a reason. But it seems to me we'd eliminate a lot of questions about what happened during the interrogation if they were videoed.
We'd eliminate a whole lot of stuff. It's always this happened or this didn't happen. My client said this, they say this. We spend more time on that. Video, everybody's got technology in every police station in the Commonwealth. Flip a switch, put your cell phone on. But you guys up there have to make it mandatory because nobody's going to agree to it. You got to make it mandatory. Can't give people the wiggle room out or they're not going to do it. Just a couple of, I'm almost done with you. I just want to ask you a couple of things. I won't go through all the cases that I gave you, but I want to just ask you a couple. That one. This one I already did. Oh, the Santiago case on sealing of records. I guess my question in general is, why are we even having any discussion about somebody's ability to seal a record? Why shouldn't everybody that got a not guilty, a dismissal, placed on file, whatever, why can't anybody go in and get their record sealed?
Unsealed, you mean, or?
Or no, sealed if they have a quarry record. They have things on the quarry, and they're found not guilty. That stays on their quarry. First of all, why does it have to stay on their quarry? It's a not guilty. There's no provision to take it off there. And of course, it follows the person. Every time they get a job and they want to see the quarry, they look and say, oh, Jubinville was charged with this, not guilty, I must have did it anyway. Very prejudicial to people. So not guilty. And who does it affect more? The 655 than anybody. So you think people should get their record sealed, or that should be removed if it's a not guilty or dismissed?
I don't think I know enough about why it's still there to, at this point, make a policy decision on that.
Because it's always been the way we've done it.
But why?
You got me.
Okay, I would like to know why, and then I could give you an answer.
You got me. I mean, the government brings a charge against you. Then they dismiss it. Stays in your quarry record. They brought it. They dismissed it. Now I'm going to suffer. The guy's going to suffer for it whenever he goes for employment. I go to trial, I get a not guilty. It stays on my record. Now, what else? Oh, the Andrade case. The guy complained because they took a picture of him in a lineup and he was in chains, right? The court said that's okay. What's okay with that? You were on the panel, Judge Milky and Judge Green. What's okay with that?
Yeah, I think what is maybe not expressed in the opinion is that there were other pictures of him in chains, which he was not objecting to. So in the context of all of that came in, it was just another picture.
No, but
I can see why it would be prejudicial.
For fairness, right?
Right.
And even though some lawyer doesn't get off his duff and object, I'm the judge. I say, wait a minute, this isn't right that we show this picture to jury or to the witness like that. I don't know why it would need to be done.
Right. I mean, I think the explanation in that case was that it was done to show the chain of custody of particular DNA. And our review on appeal.
Through an actual chain.
And our review on appeal was for abuse of discretion. And in light of the fact that other photographs of the gentleman had come in that were equally prejudicial, we could not say that the judge abused his discretion in allowing this one in particular in.
No. I'm getting this one confused. This is the one where there were two sets of pictures? Or was that another case? They showed the first set of pictures with an audio and video on it.
And at one point, the audio.
Then the person didn't make an identification. So when the police left with the witness, they said, oh, the witness said, I want to see them again in the hallway. So they showed them again. And she said, oh, it looks like the guy.
Right.
And you guys said that's okay.
Right.
I got to tell you, just being the suspicious person I am, I read that and I said, oh, you got to be kidding me. They fell for that? Somebody says no, and it's all on tape and recorded, and then walking out. Oh, by the way, let me look at the picture again. Why wouldn't the cops bring them back in on the video and say, okay, I'm going to do it again on the video? You guys said nothing wrong with that.
Well, I mean, I think one of the things that you're not saying is that the gentleman was on the hospital bed.
Yeah.
After suffering the injuries, and it wasn't like the witness was walking out with the police and there was nudge, nudge, wink, wink. It was the police were
How do you
walking
know
out,
that?
and then there was nothing in the record to show that.
Of course
the
there
only thing
isn't.
in the record was that the witness was in the bed.
Was what?
Was in the bed, in the hospital bed. Yeah.
But you, of course, there's not going to be anything in the record about the wink, wink. Of course. Okay, well, that's it with me, I think. I want to tell you that I loved reading your application again. You just have such a really unbelievable background in law that I've never seen before by anybody that's ever come up here. You a patent lawyer? How many people are patent lawyers that go on to other things? You were an engineer for companies. I mean, absolutely incredible. You would be making millions of dollars right now. It is really impressive. I really congratulate you on what you did.
I appreciate that, Counselor. Thank you.
I think you'll be a wonderful Supreme Judicial Court judge. But just be bold, will you? You're at the top now. Nobody can do anything to you when you say things. Nobody. You're gonna, be bold. Change this stuff. Change this racism. You can do it. Or you can start.
I hear you. Thank you.
Thank you, Your Honor.
Thank you very much, Counselor. Counselor Ianella.
Thank you. I won't be as long as my good friend from Milton. I just want to make a comment. First of all, Counselor Juvenville talked about, it's just so unfair, and we all agree that people are in jail for so many years. They didn't commit the crime, and then eventually they got out. I actually chaired a commutation hearing over 30 years ago in this council. It was Joseph Salvati and 3 other people. They were all charged with first-degree murder. They exhausted all their appeals. And then the governor, I don't know who the governor was at the time, might have been Dukakis or somebody, but he recommended to the parole board did it, and for a commutation. And those 4 individuals, actually one of the individuals died in jail, which is so unfortunate. Never saw his grandkids. It was just a really sad story. But he's right. Those stories do happen. And there's nothing can repay those people and these people spent we're talking over 20 years. And I know one of the individuals got millions and millions of dollars on a civil suit, but it's no money can take your freedom away. So I understand that, and I appreciate those comments, Councilor Juvenville. Systematic racism. You answer the same, he didn't press you. I mean, he made a nice comment, but at least in my opinion, he didn't ask you the question that I thought he was going to ask you. He saved it for me. Thank you. He's good like that. Appreciate it. Everyone who comes before us, whether it's the Chief Justice of this court, the judge of that court, no question, court system has racial tendencies. And they all say it. So you've been on the appeals court 3.5 years. How many members of the appeals court? 20?
25.
25. In the appeals court, while you were there, is there systematic racism?
I have approached colleagues about language that they've used in draft opinions that I personally believed exhibited inattention to the racial undertones of that language. And so I have approached them, and without exception, they've understood, they've asked questions, and they've changed the language.
And is there been any courses in the appellate court by the chief with respect to this issue? Training? And if so, when?
Before I was sworn in 2017, as I understand it, all the judges went through implicit bias training.
So since you've been there, every new member gets some type of training?
As I understand it, yes.
Has there been any discussion, like in the situation you just talked about, how you put some justices, I assume you put them aside, you didn't bring it up in front of other judges?
Sometimes in front of others, sometimes pulled aside.
So when you say in front of other judges, was like you all get together and you say so-and-so, or do you say I've heard without mentioning names? I'm just curious how it works.
So it's never about the individual, it's about the product, the opinion. In my experience, as I said to Councilor Jubenville, most people do not think of themselves as racist. And I think it's important to go beyond that and be anti-racist, to avoid the language of racial innocence, and instead identify situations or language, because that's what we work with in the appeals court, that could be supporting a racial view.
You've been on the appeals court for 3.5 years. Has it gotten better? You've said you've spoken to judges. Have other judges, at least to your knowledge, spoken to judges about, hey, this here, you shouldn't have said this, you shouldn't have said that?
Yes.
Is it better today than it was a year ago?
Yes.
So there's less racism in the appeals court today, in your opinion, than a year ago?
I think there's more awareness.
So there may be awareness of something, but the problem is no better than it was a year ago in the appeals court.
I think raising awareness always makes things better.
So you think it's better today than a year ago with respect to systematic racism in the Superior Court? They get it.
In the appeals court, I think that people have had conversations, and I've been part of particular conversations that have improved the product.
Well, that's a good thing. That's a good thing.
Absolutely.
With respect to, again, Juvenile brought this up with judges looking at defendants' criminal records. I totally disagree with my good friend on that. But what's your opinion on that? Do you think judges, once somebody is convicted of a crime, should look at an individual's criminal history?
I do.
I agree. What about in setting bail? Do you agree they should also look at someone's criminal record?
I think it should be part of what's looked at, yes.
I agree. Just about done. I told you I'd be quicker. Are you familiar with the SJC decision last April on the election nomination signatures? The case was brought before the SJC, I think it was in April. Basically, because of the pandemic, they reduced the requirement for candidates running for office. I think they cut it in half. Are you familiar with that?
I am.
And your opinion of that decision? What's so funny? Your opinion of that decision?
What is my opinion of that decision? I think in the absence of any legislative fix, given the COVID situation, the SJC did address the problem. I don't know how the 50% number, 50% of the signatures, I don't know how that was arrived at, and it's not clear to me from the decision how that was arrived at. It was clear to me in the decision that nobody was arguing the other side. And as a judge, you need a blue brief and a red brief in order to come to an equitable decision.
I'm not sure what you just said when you said there was no legislative fix.
Yes.
What do you mean by that?
Well, I mean that there was nothing done by the legislature to reduce the number of signatures in any way in light of the pandemic.
Totally disagree with you.
Was there something done?
I'm going to tell you.
Okay.
Well, first of all, I don't know the exact dates, but I think the signatures came out like February 7th, give or take a day or 2 or 3, and they were due April 21st, again, give or take. That's about 10 weeks. I mean, there were members on this council. I know Juvenile was the first one. I was the second one. We got all our signatures before March 7th. Okay, they wouldn't even count all my signatures at the Secretary of State because I had too many. So when you say there was no legislative fix, do you think all the legislators were away in Europe and they didn't know what was going on? Of course you don't think that. They knew what was going on. And I say to you, it was their opinion. Again, obviously, I didn't talk to these folks. There were bills in front of the legislature. But it's my opinion that the legislature said, you know what, they have 10 weeks to get signatures, pandemic or no pandemic. People should be able to get it. And because of that, we're not going to do anything. So I think the fact that they didn't do anything doesn't mean they didn't have a fix. Their opinion, the way I looked at it was, yeah, we look at it, hey, 10 weeks, we know there's a pandemic, we know there's social distancing, but we don't think there's a need for it. So when you say there was no fix, I know you're saying, well, they didn't reduce it 20%, 10%. But I look at it the fact that they did do their job. They looked at it and they didn't think they had to reduce it. That's the way I looked at it. You don't see it that way. Could you at least see how a reasonable person would see it that way? Because I'm not saying, I'm not, the SJC, when you say they didn't fix it, it's almost like saying that the legislature was inept or they were asleep at the job. I'm not saying that. I'm saying they did their job and they didn't think there was a need to make a change. Your thoughts?
I don't know that anybody presented that argument to the SJC that inaction was actually affirmatively sticking by the numbers that were at issue. So
would that have been an argument you would have thought was reasonable?
It would have been an argument that would be reasonable and I would have heard. I don't know if the outcome would be different, but it definitely would be an argument I would hear.
I always thought that it was the legislature who sets the rules with respect to elections. This SJC changed that, obviously. Who do you think sets the rules when it comes to elections? The legislature or the SJC?
As a general matter, it's definitely the legislature. It's a legislative function. I think the case raised an issue in light of the pandemic. And as I read the decision, the justices felt that there had been no action by the legislature. And I realize your argument is that inaction was action, but I'm not sure that argument was made.
You should have showed up for that. No, kidding. Because, I look at it, sometimes there's special elections in the winter. Does that mean if we have some big snowstorm and, I remember in 1978, there was a snowstorm. You couldn't go outside, drive the cars 3 or 4 days. Legislature, they don't do anything, or they feel the inaction is action. Is SJC going to get involved? Now we have a hurricane. SJC going to get involved? I think it's the legislative body that should set the rules. Obviously, you and the other members, on the SJC, but obviously have a different opinion. Because I have a lot.
I don't know that I do have a different opinion.
Okay.
I'm just reading the Goldstein decision and telling you, this is what I read.
Okay, no, fair enough.
Yeah.
Fair enough. No, that's good. I don't have any other questions. It was a pleasure to talk to you over the phone. You were here not too long ago, 3+ years.
Correct.
You've done a great job from what I hear from the people in the appeals court on most of your decisions. I don't know all of your decisions, but I think you're going to be a great addition to the SJC, and I look forward to voting for you when your name comes before the council next week.
Thank you, Counselor.
Thank you.
Thank you, Counselor. Counselor Duff?
Thank you. Thank you, Governor. I'll shift a little bit from some of these questions. Same subject. I frankly, as a white person, find it interesting when we ask people of color how we should be less racist. And I will leave it at that. But I do think the points brought up around inherent and systemic racism really call for us more than ever to not just be doing education in the courts, but in the legislature and in this body of the Governor's Council itself. Self-assessment, we talked about it last week. I think it's a great idea. That said, can you share with me your involvement with the MBA tiered community mentoring program? And how does that program promote diversity?
Thank you, Counselor. So this is the brainchild of then Chief Justice Angela Ordonez, who set up this program with the MBA, which pairs high school students with law students and a practicing attorney in a mentoring circle. And the goal of the program is to get people to think early on about different careers in the law, not necessarily being lawyers or judges, although that's an option, but introducing people to probation and to the various other aspects of the legal system. I do a presentation with a court officer every year, and I learned as much about his job as he does about mine, and it's quite interesting. And so the idea is to get kids early on thinking about a career in the law, something that they might not otherwise be exposed to in their own home.
Thank you, and thank you for expanding on that. It's just not lawyers and judges in the law. This is a softball, but how does your engineering background factor into your qualifications for the SJC?
Sure. So I think as an engineer, I was trained in critical thinking, which means that I don't just accept the status quo. I will question things like, why are we doing this particular thing this way? And I'm not afraid to ask that question and be thought of as stupid for asking the question. I'm confident in my intellectual capabilities so much that I can ask the question that nobody else wants to ask, but everybody else has on their mind. And then engineering helped me solve real world problems. I think unlike scientists, engineers have to deal with limited resources, right? You solve a problem, there are constraints on your problem, and you don't have infinite resources to solve them. And so you don't wait for the perfect solution. You adopt the solution that's right for the moment and tweak it along the way. And I think in our judicial system, that's helpful. As somebody who's willing to find today's correct problem solving.
Great answer. I actually went to a liberal arts college where I was required to take the art of critical thinking as a philosophy course before I was allowed to graduate. I passed, but I don't know how well I did. Anyway, I think your background, as we had discussed earlier, on patent law is tremendous. I mean, your writing is superb, the list of articles and publications. One thing that I'm particularly interested in, you challenged a company's patent on a method for screening markers in maternal blood to determine if a fetus may carry Down syndrome. And you argue that the markers are naturally occurring phenomenons in a woman's body. So screening them, using them as a known technique can't be patented. Could you share a little bit more about that case? And you can put it in language that we can understand, because I'm sure it's quite technical.
Sure. So in that particular case, we took this test that was being used to screen women who, like me, had kids over the age of 35, and it was using the natural markers in a woman's blood to determine whether the child might have Down syndrome. And we argued that it was not patent eligible subject matter. That is, you can't get a patent on something that's naturally occurring, that you haven't done something with. And so the point was to allow our client to give these tests to women without having to pay a royalty to the individual who said that they owned this, what I call an algorithm.
That's fascinating. Okay, we'll shift a little bit to technology because we talked a little bit about some of my favorite people in the world, Megan Smith, who was also a mechanical engineer at MIT. I don't know if your husband knew her. Well, she was there, and Chief Technology Officer of the United States under President Obama, and my former boss. She taught me a lot about things I kind of understand today. I still don't. But my background at the FCC with Commissioner Chong has an ongoing relationship that I have with her, and we talk, even though she's in California, on a fairly regular basis about the issues that our country is facing today. And I want to stay out of judgment, but I think so many people feel that to the consumer, under the current FCC commissioner, the FCC is a little bit hostile to consumers. That's my opinion. That's just, I'm not saying that's a fact. That's Eileen Duff's opinion. So one of the biggest issues that I am concerned with is net neutrality. And you and I spoke a little bit about it. I'm not sure everyone really understands it. It's very complicated, yet very simple. It's really the access, what we are able to access on the internet today is pretty free and out there. I'm not saying free that you don't pay to get on the internet. I'm saying the information you can freely select. Under AJ Petit, the current FCC chair, and under this administration, they are limiting that. California has imposed or has written their own laws on this. And I believe there are 8 other states that have too. One of the reasons I find you, besides you have a great legal mind, but I think your background in technology, in patents, is going to be incredibly valuable to the court, but to the citizens of the Commonwealth to really understand how these issues are going to affect people. Can you share a little bit of any knowledge you might have on this issue and any philosophy you may have about it?
Sure. So without judging whatever Massachusetts may be doing.
I don't know that we're clearly, I want to be clear, and I don't know, but I don't think we're doing anything. And that's not a criticism, and LG may know more than I do, but this is an issue, and the reason I'm so concerned about it is because it is an issue people are not paying attention to. And it will determine what your daughters can read on the internet for college and school, and it will determine what information we can get. And I think it's one of the great civil liberties, or however you want to frame it, issues of our day. And it's a political hot potato. There's the FCC, how much companies will impose their power. They may or they may not, but we don't know. So anyway, I'm sorry, I'm babbling on, but if you would share with us your thoughts.
Sure. I mean, as I understand net neutrality,
yeah.
And I preface this by saying that my engineering degree is
mechanical,
mechanical and a million years outdated. is net neutrality is the idea that internet service providers cannot discriminate based on content.
Correct.
And the elimination of net neutrality affects us all in that if the internet service providers are not required to have a neutral view of all data content, they can prefer some content.
Mhm.
So if I'm an internet service provider and I want you to watch my program, I can issue it at a faster speed with no delays. And if my competitor has that same service, I can slow it down. And so it benefits me if I'm an internet service provider. Now, we see the problem with that, and I think it's really acute during the pandemic, because so many people, like you're referencing my daughters and my son in college, they are using the internet to get to their classes, right? None of them are going in, Elise goes in 2 days a week, but that's it. Other than that, during this pandemic, they are needing to have their data from their schools come to our home at a rapid pace. And if you eliminate net neutrality, that could interfere with their coursework. It could interfere with the appeals court, where all of our hearings have gone online, and without any regulation as to that. You're right, that could potentially be a problem if you allow the internet service providers to just free reign, do whatever they want in terms of the speed at which they deliver content.
And that's what this current administration has done. That is actually the law right now from the FCC, is that they can regulate it. People don't understand it. And that's why I think it's incredibly dangerous. But as you stated, this is a multi-billions of dollars are on this. And as somebody who worked at the FCC on the Telecom Act, the money is, the numbers are mind-boggling. It reminds me a little bit of over 20 years ago. We used to do 7-digit dialing in the United States. At the time, I was working for McCall Cellular, which became AT&T. This was right before I got appointed to the FCC, and I represented California for that company in all the numbering negotiations, because people didn't understand that we were going to 10-digit dialing, and that there were billions of dollars tied up in it, because who controlled the phone numbers when it was a new industry and there were new carriers coming out all the time? They were the big Ma Bells that controlled them. And they became like vanity numbers. I just find this, if anyone had ever told me I would find telephone numbers interesting, I would have laughed, but it's actually a fascinating business. My last thing on that, again, is, and I don't really know what, I actually do think not that I know, but I do have an idea on it. Currently, the Federal Communications Commission is also relaxing or eliminating completely the rules for cable companies providing local access into our communities. And so probably 20 or 30 years ago, in the early 80s, when cable was new, part of the negotiations and this was the industry I started in, was cable. Part of the negotiations in every single community in this country was a franchise fee, usually 5%, and money set aside to provide local access channels, studio equipment, and a lot of times for the high schools, for the students to learn AV and all that sort of thing. This is now being all eliminated under this administration. Again, something no one is paying attention to. And my suspicion would be at some point it could end up in the courts. And so I guess I'm just really trying to ask you to be aware of it, because the municipalities in this Commonwealth negotiated in good faith, albeit it may have been a long time ago, but that was part of why they gave people access in rights of way. And it concerns me that it's sort of no one's paying attention and they're going to pull the rug out on it. I've already started getting emails from people saying, can you pitch in $10 so we can keep our local access channel open? And these channels serve a purpose, not just to educate our kids and help our students, but seniors and other people take advantage of them, and they have programs and they're wonderful things. So I'm not going to ask you to comment on that because I think it's still evolving, but I will ask you to be aware of it. And I think a lot of us are going to look at you just because you're the only engineer there, thinking you're going to know everything. You're like the Wizard of Oz for us. But your background, Judge, is just such a perfect dovetail for our times of patents, of intellectual property, of telecommunications. I mean, all of it may not be your expertise, but your science background, I mean, you're undergraduate from one of the top 5 schools for mechanical engineering. You're a graduate from MIT. Your law degree from Stanford. I mean, you're smart. But the other thing that I think Attorney Lukey said about you earlier that really resonates with so many of us is that you're kind and you're humble and you are willing to have conversations about race and diversity. And I thank you for bringing that up because all of us have issues with this, whether we know it or not. And it's why we all need to do self-assessments and training. I applaud you for your work. Thank you for applying. And my last comment will say, I think your introduction today was literally the best introduction I've ever heard. I ask the mayors in my communities this is live streamed on YouTube. I let them know it's happening. I ask them, schools are struggling for curriculum today. This is a civics lesson. This is a live civics lesson that students and teachers can tune into. It's also taped, and I think I will be making those resources available to my communities in my district. And your very eloquent explanation of who you are bilingually, I just can't tell you how important that is for so many of our students. In your story about your dad, what a hero. Your parents, absolutely heroic to leave their homeland and come here with nothing. And my mother's first generation, but we didn't come from those dire circumstances. I've had the opportunity to travel quite a bit in developing countries, and I think when you see what people go through to become Americans, you really have not just a deeper love for this country, but a deep respect for them and the challenges that so many face today still. So your parents did a great job. Thank you very much.
Thank you, Counselor.
Thank you, Counselor. Counselor Kennedy?
You getting tired yet?
I'm good.
I've only got a couple of hours, so. I've gone over a lot of things with you prior to today that I'm going to ask you about, and some of it you can't comment on because it's going to be coming before you shortly, but I want to talk about a couple of things, okay? Because I think it's important. One deals with how we're dealing with evidentiary hearings in the courts right now. And I talked to you a little bit about the fact that a lot of judges in Superior Court, I haven't seen it in District Court, in Superior Court, are trying to push their docket during this pandemic. They can't do trials, but they feel like they can do motions to suppress, motions to dismiss, and things of that nature. And they're pushing, some of them are pushing pretty hard. And I know they're coming up because one judge ordered a defendant to go forward on Zoom. It went up to a single justice, went before Justice Gaziano, Justice Budd, now Chief Justice Budd, as of an hour or so ago. And she issued a stay on that. A second case, and that's good, that's before the court. A second case was brought before, I believe it was Judge Locke in the Superior Court, where he wanted someone to go forward, gave him the option of going forward either in person or on Zoom, and said, you know, it's one or the other, and I'm ordering you to do one or the other. I'm giving you the choice, but I'm ordering you to do one or the other. And that went before Justice Gaziano, and he declined to stay because they were given the choice of not going in public. And that case is coming before the court. I don't see that as a real choice that they're giving people when your choice is that you're doing a motion to suppress on Zoom, where you can't effectively, as a defense lawyer, cross-examine a witness. I think it deprives the defendant of his right to cross-examination. And giving them the option of going to court during a pandemic isn't a real choice either, because a lot of people, for a lot of reasons, don't want to go into a public courtroom. It might be because they have pre-existing health conditions, and I don't think I should have to tell you as a judge what my pre-existing health conditions are. I think that's private. I actually had a judge, I had a surgery scheduled when I had a Superior Court trial scheduled one time. After finishing a 2-week trial in front of Judge Laureate in Superior Court, in the middle of that, I had a rape trial scheduled that was held day to day. And when I went in front of that judge, I said to her, I postponed a surgery. I have to have minor surgery. I have to have it. And I need a postponement. She made me get a letter from my doctor, which I took great offense to, very frankly, because it was none of her business what it was, and it certainly didn't belong in a public record. By the same token, a lawyer shouldn't have to say, hey, judge, I don't want to come in the court because I have a pre-existing condition. I don't want to come in the court because I have an elderly mother or father that I'm taking care of. I don't want to come into court because I have a child with diabetes that could be exposed and be at high risk because of the COVID. I shouldn't even have to say that. So putting lawyers in the position where they have to either go into court, or in my opinion, I've been doing criminal defense law work for 37 years, not as long as Counsel Jubinville, but I think he would agree with me on this. You can't effectively cross-examine someone on video. There's a whole dynamic that goes with that. It takes place in person in the courtroom. And you're going to be dealing with that issue. And I just wanted to lay out what my view of it is, that during this pandemic, there's no reason that any case like that has to be pushed to move a docket. I'm not talking about custody cases necessarily. I'm not talking about, in the cases that I described, I don't think the people were in custody, okay? You know, we're going to have a vaccine rolling out January, February, March, probably widely distributed by the end of next year. What's the rush to move a docket? You're either giving a choice of ineffective assistance of counsel, which you'll be hearing millions of. If this is what happens, it'll be one after the other, or putting your health at risk, or your family's health at risk, or the court employees at risk. I give the court a lot of credit for a lot of the things that they've done, the court system in Massachusetts, since March, when the governor ordered the shutdown. And that shutdown was absolutely necessary. I'm surprised we're not in the middle of another one right now, given what the numbers are doing. While we were sitting here, I got a flash on my phone that said we had the highest number of deaths during this pandemic in the United States yesterday, the highest one-day number. We're in a major surge across the country. We're in a major surge right now in Massachusetts. I don't know if it's as bad as it was in March and April, but it certainly seems that way. I know the death rate isn't as high because of treatments that they have now, and they've learned how to treat it, but I'm still seeing numbers of 20, 22, 23 people a day. Guess what? To me, that's high. If you told me last January that we're going to have a pandemic that was going to kill 23 people a day in Massachusetts, I would have been horrified. Now we've become desensitized to it, and we're saying it's only 23 a day. In that short time, the courts have done an amazing job using technology. If you told me in January that I would be doing court appearances on Zoom I would have said, what's Zoom? Okay? So it's, they really have done a lot of things. There are still a lot of problems they have to fix. And I talked to you about some of those. And one is these bridge lines where you're just on the telephone. I have personally had some disasters happening on the phone. I described one to you that happened in the district court where I was never unmuted and a hearing took place with the other side arguing a case when I'm screaming, I'm here, and the clerk never unmuted me. And the whole hearing took place, an order was issued, and it took me a lot of time and effort to get that undone. I think we have to do away with those. I don't know why every court's not on Zoom. You go into Malden, you go into Cambridge, you go into Chelsea, you go into Suffolk Superior, you go into Middlesex Superior. They have cameras. They have video. People are on Zoom. You know, if that case was going on, I could go and get someone's attention if I was unmuted, if I was still muted. You can't do that on the phone, and you just sit there. The other day, I had a call into Lynn Court. I called in about 20 times. There was technical issues where it was just all static, which I didn't know it was at their end. I thought it was at mine. After an hour, I hung up. I drove there. But I didn't want my client defaulted because I wasn't there. Because I don't know why some courts and even some courtrooms in the Boston Municipal Court, some of them are on Zoom and some of them are on bridge lines. I don't know why. If it's a money issue, well, we can deal with that. We can talk to the governor's office. We can talk to the legislature. But what we're doing now in terms of that part of the technology isn't working. And it's causing a lot of problems. People are getting defaulted on telephone lines and warrants issued for their arrest when we don't even know if they know the phone number. But that said, I think the court has done an incredible job in a short period of time with the technology part of it. They haven't done such a great job with the health part of it. First of all, there's a lack of consistency in terms of how courts are handling social distancing, number of people in the courts, who has access, who can come in, who can't, what happens when someone tests positive. And that's something you're going to have to deal with in your superintendent authority as part of the court. There is no consistency. How it's handled. They basically left it. It's similar to what's happening in this country. You know, the current administration has basically left it up to the states on what to do. The states, in particular, I think the governor and lieutenant governor have done a great job with what they have, but viruses don't know borders. They also don't know courthouses. And we have to have consistent policies in place. Some courts I go into or I practice in, no one's allowed in the building. Everything's on Zoom. Some courts you go in, I described the Lynn District Court the other day, they have an occupancy limit, 59 people. I don't know where they got it. I don't know where it came from, but it's 59 people. The problem is right outside the court, there's 100 people in line not socially distancing, half of whom have masks, half don't. And they're letting them in one at a time. And I'm going to ask you to comment on these issues in a moment, but the other problem is we're leaving presiding judges in charge of how to handle an outbreak. I probably know every presiding judge in the Commonwealth of Massachusetts at this point between practicing law and being on this council. And I don't know one of them that knows anything about viruses or how to handle a pandemic. They're not trained in that. They have extremely loose guidance from the trial court, and I'm not 100% sure where that's coming from. I raised that with Chief Justice Budd last week, and she pulled out a folder and talked about what they're supposed to be doing, and my response to her was very simple. It's not happening. That's not what's happening in the courts. We need consistency, and we need policies in place until this vaccine comes out, these vaccines, and until this pandemic's under control. It's not there. And You have to do something about that as a member of the Supreme Judicial Court. The body does. And you have to do it soon because people are going to die. After I had this conversation with Judge Budd the next day, her hearing was on Thursday and Friday, I got 2 phone calls. I don't know if I told you about those. I think I did. The first one was from an assistant district attorney that I was supposed to do a live motion to suppress with yesterday. She had no symptoms. She tested positive. I would have been in the courtroom with her. She thinks she got it from the Lowell court, the brand new building, because that was the last place she was in. And I hung up the phone, and within 3 minutes, I got a call that was much, much more serious. It was from a criminal defense lawyer who's a bar advocate, who was a friend. And he called me because he had COVID. He's a little under 50, I think, or high 40s. He had COVID, and he had a very bad case of it. And he believes he got it from a client who was in custody. And he was ordered to, he had to do a 58A hearing with the client. There was a lot of interaction. The client was sick. Probably shouldn't have been brought into the courtroom with or without a COVID test, but was sick. And the judge kept saying to the client as he's coughing, pull up your mask during this 58A hearing. You know why he couldn't pull up his mask? He was in handcuffs. Yeah. Couldn't pull up his mask. He believes he got it from that person. That particular lawyer is over the COVID, the virus itself, but has a lot of really bad after effects. He has organ damage. This was last Friday, he called me, extremely distressed. And the most distressing part of it was, and he sent me this afterwards, he didn't have a document that the police didn't drop off when they brought him to the courthouse. The document was on the booking sheet. It actually said he tested positive for COVID. Now you can understand why that's extremely distressing. And extremely distressing, obviously, for him and everybody else that was exposed to him. That person was held, and the lawyer told me he called the Bill Ricker House of Corrections to say, just make sure this guy's quarantined, make sure he's got it, you know? And he called, talked to the client 10 days later, and he still hadn't been tested or quarantined in the Bill Ricker House of Correction. And he emailed me the documents. I didn't produce them because I didn't want to give the names out. We have to fix this. It's too important. Courts have been opening and closing all over the Commonwealth as people are testing positive. You probably read it. I'm sure you get Lawyers Weekly or the court notifications. Lowell's court closed this day. Salem court's closed that day. Suffolk Superior's closed that day. It's happening every week. You agree with me?
Yes.
Are you seeing that?
I am seeing that, yes.
Okay. So a courthouse, at least 1 or 2 courthouses, closes every single week because somebody in the building tests positive. Agree with me?
Right.
Hmm?
Yes.
Okay. I'm deaf. So, and what they're doing is they're closing down for 2 days, supposedly doing a deep cleaning. Now, the bar thinks that deep cleaning means some special company comes in and cleans everything. It's the custodians that clean it. And they're not experts at decontaminating viruses or anything like that. I think that leaving it closed for 2 days, the virus is going to die by itself anyway. But what they're not getting is that it's not about cleaning that surface. It's about the people that person exposed. And I asked Chief Justice Budd that question, and she read to me about who would be notified. It's people who had been in contact with somebody for 15 minutes or more within 6 feet. Nobody's keeping track of who's going in the building. Anywhere, in any court. There's no contact tracing. I went to Tony C's for lunch right down the street from the Malden Court. They took my name and telephone number when I went in the door. Nobody's taking any contact information when you walk into a courtroom. I was in that courthouse. I think the lower court, I think, just closed again yesterday. I was in there 2 days ago. Nobody's contacted me to tell me that somebody tested positive in there. Nobody's keeping track that I'm there. And we have to fix that as well. These are serious, serious issues. And we just have to do something. We have to do better. The courts have to do better. You're the third branch of government. The governor and lieutenant governor can't tell you what to do. You're setting your own policies, and I believe, at least when Ralph Gentz was the Chief Justice, there was a lot of communication going on what to do, as there should be, and I hope there still is, or will be with Chief Justice Budd and the other members in terms of this. But we got a disaster going on. The CDC guidelines, as I read them, say if I'm exposed to someone with COVID, what am I supposed to do?
14 days quarantine.
Okay. And somebody in a courthouse is exposed to COVID. They close for 2 days. And you know who's back in that courthouse? All the employees. A police prosecutor in one district court 2 weeks ago tested positive on Monday. They closed for 2 days. They opened on Thursday. Friday morning, I was walking into that court. The court officer came up and he said, "Terry, you want to leave? We're going to close." The clerk magistrate tested positive. You know who the clerk magistrate was with on Monday doing hearings? The police prosecutor. It's crazy what we're doing. We're exposing a lot of people to a deadly virus because we're not doing it right. And it's very hardworking court employees, judges, clerks, staff, custodians, court officers, and all the people that come in there. And I think we can take some very simple steps without closing everything down to fix that. That's one of the things you have to do. Now, given what I said, what do you think you're going to do? I'm going to pretend I'm Bob Juvenile. How are you going to fix it?
Well, I think on day one, getting a sense of the problem.
I just gave you a sense of the problem.
Well, you gave me anecdotes.
Well, no, I gave you this. They're more than anecdotes because I've been to a lot of courthouses and I see what's going on. And one of the things that Chief Justice Budd said to me when I raised this was, well, we're not directly in touch with all that. Everything you're going to get there is going to be filtered 8 different ways. And what you think is going on is not necessarily what is going on the ground. But go ahead.
So no, I appreciate that. And, you mentioned earlier somebody asking for a doctor's note. In my view, all members of the bar have an obligation to tell the truth. And so if you're in my courtroom and you say you have minor surgery, I don't ask any further questions. I don't need a doctor's note. And so I believe the specific situations that you're articulating. I don't question them. But not to hearken too much on my engineering roots, but one of the things that we have in engineering is something called quality control. So you design something, right? So let's just say Chief Justice Budd had that envelope of guidelines that you are suggesting that she had.
I haven't seen them. She pulled them out, but I've never seen them.
So let's assume she's telling the truth.
I believe her.
So there is these guidelines. And so the question now, it sounds like, based on what you're describing, is the implementation and the quality control.
Well, when I said I didn't see them, I don't know what they say. So I don't know if they're going to work. Not that I would anyway, but
let's assume that they're scientifically driven, that they're informed, and that they're the best practices. I have no reason to believe otherwise. It sounds like, though, that there's been a failure of implementation. And I think that one of the things that one needs to do is to do what I do, which is travel to courthouses and see how things are going, how they're actually being implemented. I think if presiding judges are not given the scientifically driven protocols, that's a problem. Because as you,
I don't know. I have no idea if they're giving them or not. I assume that every presiding judge is being given whatever the guidelines are. I assume.
Right, but I think that your assumption might not be on steady ground if you're not seeing consistency from place to place. You would see some consistency if everybody's been given and has implemented the guidelines, I would think. For me, that's a red flag.
How about if you don't know I was in the building? You know, one of the things Chief Justice Bud said was that, well, we notified the people that were in close contact with that person. Well, number one, I don't know who the person is. They don't give that out, and I get that. That's privacy as well. But so you have to let everybody who was in that building know. You don't know I was there because nobody wrote it down anywhere. Nobody took that information down.
Right, and that seems like a fixable problem.
Okay, so how are you going to fix it? This is an emergency. This isn't something that you can go out. You can get. We can vote on you next week. You can get sworn in the week after, and try to settle in. Something's got to be done like now. Yesterday.
Yeah, and it seems to me getting the contact information like you provided to Tony C's is something that could readily be implemented. I don't see why that wouldn't be an easy fix in terms of contact tracing.
And just in general, there's not a lot of communications with the bar. I think, what I've been told is a lot of people in the courts that discuss how to do things and what we should do, they talk to CPCS, which is great. I'm not CPCS, and neither are most of the practicing lawyers in the Commonwealth of Massachusetts. So I don't think they're reaching out to a wide enough group of lawyers that go into the courts, which includes, from your background, the civil bar. They're not necessarily have anything to do with that. That use the courts, if not as much, even more, actually. I think there are more civil filings than there are criminal. Nobody's reaching out to them in any way in terms of information of what's happening. I happen to get notifications because I have lawyers weekly that Lowell Court closed on my phone. I get it that Salem Court closed. Not everybody's getting that. And I think that's one of the things that has to happen is more communication. We only have to ride this out, I think, for another 6 to 10 months. But we got to fix it in the meantime. All right, I'm going to move on. One of my big issues with COVID-related issues, which Councilor Jubenville touched upon, is 58A dangerousness hearings and the Rules 36 exception. The SJC, when this pandemic started, said basically suspended counting the time for people held for 120 days or 180 days. You would agree with me that as a general rule, cases that are in district court tend to be less serious than those in Superior Court.
Yes.
Generally.
That's not to the individual involved, but
that's
yes.
not to say that there aren't some serious cases in district court, but as a general rule, do you think anybody should be held prior to trial when they can't get a trial because of COVID indefinitely with no end in sight on a district court case?
I couldn't comment on that.
Well, we got somebody held for somebody who on March 2nd, a dangerousness hearing is being held. Okay. And a judge decides, okay, I'm going to hold him for 120 days. It might be a cooling off period, as Councilor Jubenville referred to. And it might be a case that's going nowhere. The person might be getting a not guilty or a dismissal. Okay. The 120 days is up. Attorney Kennedy goes into court and says, Judge, time to let my client out. Let's have a bail hearing. Says, oh no, that 120 days doesn't count. The SJC has basically stayed these. It's going to stay there until we get back to doing jury trials. There are people still sitting there since March, since that happened, who have done more time than they would do on the underlying case. You made a face. You look puzzled by that.
I'm not puzzled. I'm definitely concerned.
It's going on.
Yep.
I personally have one client. I'm going to be resolving the case tomorrow, but that where they're doing more time than they would ever do, and on cases they may never go to jail on, and they're just sitting there with no end in sight. And some of them could get out of jail very easily if they want to plead guilty. But that's not a good reason to plead guilty, to get out of jail. You'd agree with that, right?
I would agree with that, yeah.
Yeah. So they're sitting there and they have no idea when they're going to get out. None, because what they've said is Rule 36, this is excludable time under Rule 36 until we start jury trials. They don't know. Do you think that's right? COVID or no COVID?
And no COVID, I don't think that's right.
Okay, so now we put COVID in there.
Yeah.
Do you think it's right that it just goes on and on and on? They have this city, this is the United States of America. They're sitting in jail, accused of a crime, not convicted, some with no records. And they're sitting there and they have no idea. There's no end in sight. They don't know when they're getting out. Isn't it time to stop that, at least in terms of people that have been held, except in the most extraordinary circumstance since March, that have done twice the 120 days at this point?
I think it's a case that should be brought.
Well, the problem is bringing that case takes a long time and they're still sitting there. And it was sort of a general rule that was set by the SJC, a COVID rule. And I think it's something they have to relook at. I can't tell you how many people it's affecting. I can tell you there's a lot of them. And when they talked about in the decision and I think Chief Justice Gantz wrote an opinion on it about bail issues and reviewing bail and letting people out. There were two exceptions to that. He said, we don't have the authority to let people out when they're doing a sentence. And 58 days, dangerousness hearings. They said you don't let them out on those. Now, I think your family should be extremely proud of you. You are, when we met the first time when you were going to the appeals court, I think I said it to you that I don't think I'm going to ask you any questions because anything I'm going to ask you is just going to make me look dumb. I think you're certainly one of the brightest people I've ever met, and certainly one of the brightest stars of our profession, a profession I'm very proud to be part of. I think that when I saw the governor made your nomination, I couldn't have been more delighted. I think you are a role model for a lot of Latinx, a lot of women in the bar, and for your children. And I think that they should be very proud of you, and the family should be very proud of you. And I'm looking forward to voting for you if we're voting next week.
Thank you, Counselor.
Thank you, Counselor. Thank you for raising some important issues, very timely issues, obviously relative to COVID protocols and the trial court and the safety of the people who are interacting in our courts. Thank you. Counselor Hurley. I don't know why you always have to go last, but maybe we need to do something about that. We can reverse the order next time.
The first shall be last and the last shall be first. So let me first congratulate Counselor Kennedy for being the Dr. Fauci of Massachusetts. I think he raised some really good issues. And it is concerning. Having been a district court judge, I can testify that one hand doesn't know what the other hand is doing. That when I sat in courts in Worcester, as opposed to courts in Western Mass, as opposed to courts in the eastern part of the state, everything was done differently. So if anybody thinks that the courts have this perfect plan that everybody implements, it's not happening. And I raised, after I talked to Counselor Kennedy, I raised it with the Lieutenant Governor, and I really think that police departments should be advised, or a set of rules should be set up for the police departments, that when somebody's tested for COVID, and there's an alert that goes out when they're coming to court. Same thing with the fire department. If there's hot spots, fire department should be notified of that. And I think the court system has to do a much, much, much better job than they've done. I'm just going to ask you a few questions. What do you think of jury nullification?
I don't have a thought about jury nullification, other than I think the jury should follow the law, but obviously in our system of government, the jury has the final say.
Well, everybody says jury nullification is wrong, and it is wrong because they're not following the law and they're not finding facts as they are in reality. So if that's true, then Counselor Jubinville's suggestions that you as a judge nullify the law as it exists, is judge nullification any better?
No, I mean, I think that I know my branch of government, and it is not the legislative branch. And so I think the legislative branch has the policy making role.
All right.
And I think that's right, because the legislature has a lot more capability to get in a lot more data than I do.
Well, maybe they're getting data and maybe they're not. Maybe they're just kind of pulling it all together without really thinking about how it impacts people. And there's a lot of instances of that. But sealing, for example, the legislature created the statute on sealing. So at this point, judges should follow the law on sealing. Is that correct?
Absolutely. Yep.
Okay. What are your skills as it relates to criminal law at this point?
I think that they are, well, I know that they are a lot better than they were 3.5 years ago. I was confident then that I could roll up my sleeves and learn a lot about criminal law, and I have, starting with the day I met you out in Springfield, and you told me a set of books that I should get, and I ordered them on my way home, and they arrived a week later, and continuing through this day where I look to my colleagues, especially those who have criminal defense or prosecution backgrounds, to look at my work product, to give me suggestions on where to find the relevant law if the parties haven't provided it to me. But less and less so. In the beginning, at the first year, I'd say I relied on them a lot, and now I do less so. I feel a lot more confident in my criminal law experience.
And now you're going to have Ellie Cipher, David Lowy, Gaziano, a myriad of judges Kim Budd, who are really giants as it relates to criminal law.
Yes, I hear that they know something.
Now, we spoke last week, and one of the things that I pointed out was the fact that up till now, there really hasn't been someone who's had a lot of district court experience. Most of them have been Superior Court. David Lowy was district and Superior. But in essence, last week with Kim Budd, I described what's done in the district court is reading a short story. What's done in the Superior Court, and in some cases the probate court, in the juvenile court, is basically reading a novel. But we're the court that does 90% of the business when it comes to criminal and to restraining orders. And the volume that the district court has to deal with is overwhelming. So I just want, and we talked about this, and you gave me your commitment that you would remember when you're looking at a case that comes out of district court, and we talked about this, that you're going to look at that case through the eyes of someone who's in the district court doing 110 pretrial conferences, or that's got a jury list that's got 15 or 16 cases on it in one day, or that's got 4 motions to suppress to try and get through in one day. It's like the bakery where you take a number, but everybody wants their cookies and their bread at the same time, and you can't always get that done. Now, of all the people that asked you questions today, who did the best job? You don't have to answer that.
Definitely Counselor Hurley.
Lastly, how old are your children?
20, 18, and 14.
So they're at a good age to be doing what you're doing. If I was to ask the 18-year-old if I should vote for you, what do you think she'd say?
Well, I think he would say, hopefully he'd say, I'm taking an exam right now. Can I get back to you? And then he'd say yes.
All right. Well, you're an awesome person in terms of where you came from. In terms of my science background, when I was in college, I tipped over the Bunsen burner, the hose caught on fire, and that ended my career in science. In terms of my being bilingual, I took French in high school, Spanish in college, and when I went on a tour of European countries, I was speaking half Spanish and half French in the Spanish country and half French and half Spanish in the French country. So I think the fact that you're bilingual will also add a dimension to the court in terms of understanding what it's like for people who come from a different country. I know that when I went to Argentina for a week, and I brushed up on my Spanish before I got there. Thankfully, my purse got stolen, my passport got stolen, my money got stolen, my credit cards got stolen, and I had to go to the police department, and I had to go to the consulate. And if they didn't have people there who spoke English, I would still be there. So I think you do a fabulous job in the appeals court. You're going to do just as great a job on the Supreme Court, and I'm happy to vote for you next week. So
Thank you, Counselor. Thank you. Thank you, Counselor Hurley. That concludes the questioning of our council members today. I want to thank all of you for your hard work, both, again, outside of this hearing time and within this hearing time. I learned a lot from your questions, from your advocacy. You're obviously very committed and compassionate people in terms of who you listen to within your profession and within your communities. And I thank you so much for bringing your voices forward today. I want to thank Justice Wendlandt and your witnesses. I'm not sure they all made it through the end of this hearing, but you certainly have. And I know that you learned a lot from listening to these counselors, and they will continue to be interested in following your future career, and I'm sure won't be shy about sharing their thoughts with you in the future, as they should. I want to thank you, your skills, your experience, your personal qualities, and certainly the way you described your problem-solving abilities all were part of the presentation today and certainly were questioned and brought out in more details. I want to thank you for your patience and for your contributions to this hearing today. And this concludes our hearing, and we will meet again as a council next Wednesday, where your nomination will be taken up for a vote of this council. Thank you.
Thank you.
Thank you. Thanks, Lieutenant Governor. Thanks, everybody.